has always been the court process, which is litigation, an aggrieved party commencing litigation against a defaulter and asking the court to assist in resolving the dispute. But even with this form of dispute resolution, at common law and a civil law, men of business, men of commerce had always found the court process quite challenging. And it has been for various reasons. For instance, the merchants in the UK during the inception of the common law believed that some of the formalistic requirements of the common law system delayed disputes, and therefore they believed that another system should be put in place to resolve disputes that come up between men of commerce. Another problem these guys had with the traditional common law system was the issue of commercial practices. So for these merchants, they developed their own customs and usages, which assisted them in resolving their disputes. The common law courts were not that concerned on relying on these principles to resolve commercial disputes. So these men also found this as a challenge to their dispute resolution. Another challenge they found was that the mechanism adopted by the common law courts in resolving disputes led to situations where it would fracture or completely destroy the commercial relationship between the merchants. And so they developed their own rules or customs, which in general we refer to as the lex mercatoria or the law of the merchants. And under this system, where there is a dispute, they select someone from within themselves to sit as an arbiter to resolve this dispute or the dispute that has come up. So this practice over the years led to the development of some form of an alternative dispute resolution mechanism alongside the common law system. And because this system developed by the merchants allowed a faster resolution of disputes, protected their relationships, and relied on their customs and usages, they found it more suitable to their situation than the normal or traditional common law litigation system. So from its inception, and this was not only practiced in the common law areas, in France, for example, where it was practically a civil law system, they also saw the merchants developing their own system in resolving disputes that arose between them. Borrow most of some problems with the normal court system or litigation, and therefore an alternative means of resolving disputes was developed to cure the deficiencies. And so the idea of ADR from its inception, whatever culture that had the court process of litigation. And its purpose
Hi,
has always
senior.
been
I don't know if it's just
to
from my end, but
cure.
you keep breaking. Can someone confirm if it's the same for you?
Yeah, Fatah, I'm experiencing same.
The same here.
Yes.
Wow.
I think you need to take it from when you started speaking about how the French also adopted because I didn't hear you from that point. So if you can
Now,
position yourself.
is it better now?
Yeah, I mean, you'd have to start speaking so we can confirm.
Okay, so I was saying that even with countries like France that had a civil law system, the merchants also developed some alternative means of resolving their disputes outside the traditional court system. That is to make the point that wherever the court system has developed, by which um, litigants will have to resolve their disputes in court, the problems or the challenges with the court system has led to people seeking an alternative means of resolving their disputes. And so I made mention of the fact that ADR, when you think of it, is simply certain dispute resolution mechanisms that serve as an alternative means to the normal litigation process that we know. And the purpose for the development of these dispute resolution mechanisms has been because of the challenges that we have found with litigation. So in Ghana, so this leading us to some historical understanding of ADR in Ghana. The idea of ADR in Ghana, when you think of it as an alternative means of resolving disputes, will be quite recent. It will be recent in the sense that it will start from the colonial period. Because the idea of a formal system of courts as the means to resolve disputes was only introduced by the Europeans. But before the arrival of the Europeans, or before our colonization, we already had means of resolving our disputes where family heads, chiefs, or heads of schools or clans served as arbiters in resolving disputes and made orders that were essentially binding on the disputing parties. And so the use of the word ADR as an alternative to litigation, when you situate it within the Ghanaian or African context, may be quite misleading because to us, those mechanisms that we refer to as outside the court processes for resolving disputes rather were in place before the court system. Okay, were rather in place before the court system. So technically speaking, non-litigation processes for resolving disputes to us were not developed as an alternative to the litigation system or the process for resolving disputes through the court system. However, after we accepted the common law system of resolving disputes that's using formal courts, even during the time of the Europeans, it did not entirely abrogate the pre-existing non-litigation means of resolving disputes. Our chiefs still retain some form of authority to resolve local disputes. And this continued into our independence. So after independence, subsequent governments still recognized the authority of our traditional leaders in resolving disputes. Okay, so if you look at the Courts Act of 1961, for instance, which has now been repealed, you clearly see provisions recognizing the power of chiefs to act extrajudicially in the form of customary arbitration. Okay, if you look at the LN 140A, for instance, order 72 of that law, it still maintained certain non-litigation means of resolving disputes. If you look at the current Courts Act and even the new ADR Act, it has still maintained some of these pre-existing means of resolving disputes even before the litigation process was introduced into our system. But when we think of ADR in its formal state currently, then it is a recent introduction. Now, in its current system, when we think of ADR, we are basically talking about arbitration, negotiation, mediation, and maybe conciliation and the others. Those formally structured ways of resolving disputes outside court. And one important act or situation that drove the need for ADR or systemized ADR in Ghana occurred somewhere in 1999 when Rawlings was president. The government had put in place mechanisms to attract investors. But most of these investors, in bringing their goods to Ghana, in securing lands for their businesses, ended up having protracted cases in court concerning the goods they were buying, concerning the lands they were purchasing. So it was realized by the then administration that the prolonged litigation was affecting the appetite of investors to come to Ghana. And so Rawlings requested for an investigation into how this could be resolved. And that led to the government commissioning the private sector development project to identify areas in our courts or litigation system that affected commercial transaction. Now, the study conducted by the private sector development project recognized that the prolonged litigation in courts was a disincentive to a lot of investors. And as a result of that, a task force was set up on ADR, a task force on ADR, to look into the drafting of a bill on ADR that would provide an alternative to these potential investors and to persons who would not want to use the normal court process in resolving their dispute. And this bill went through a lot of reformulation until somewhere in 2010, the bill was formally passed to replace the old laws that had already been passed, like the arbitration and the others. So we now had a full law on alternative dispute resolution. And just like we saw with the law of the merchants, it was only necessary, or its purpose was to cure a problem with the litigation process. So unlike some big parts of the Western world where formal ADR mechanisms had been in place, for example, in the US, only about 45 years ago, the Ghanaian experience is quite different because before colonization, we had our own mechanisms for resolving disputes. And today, those mechanisms are covered under alternative dispute resolution. Okay, so we already had pre-existing ADR mechanisms before what has now been introduced as the main forms of ADR. So in a nutshell, that provides an idea of our drive towards a formalized ADR sector. Now, much of the drive, as I said, came from the government of the day in response to the investor problem. But another area that we should not lose focus of is the court itself. So there are a lot of cases around this time between the 1960s and 1997 where judges gave comments recognizing the problem with our court system, either due to situations such as the caseload in the courts, the inadequacy of judicial personnel, which were leading to prolonged cases. The judges commented on all of these. So the advocacy from the recognition by the government of the day that litigation was creating investor problems, coincidentally, around the same time, happened around the same time, and that led to the drive for the ADR. So, for instance, if you look at certain cases, such as Edu versus Treme, cases like Abba versus Inframa, in some of these cases, for instance, Adade JSC spoke about the fact there's a serious indictment on the administration of justice in this country, that a simple case can take as long as 26 years in the court system. Okay. And the 24 to the 26 years happened only in the Court of Appeal. Okay. So the court recognized, the judges made some of these comments, recognizing the problem with our litigation process. And these comments helped galvanize support to push through the ADR Act, leading to the current system that we have. So sometimes you may have a question on the history of ADR in Ghana. You must define what ADR is, explain what it is as an alternative medium for resolving disputes, and talk about the fact that even with the development of the formal court processes in the West, Europe, for instance, there were always recognition of problems with litigation, and calls were made by the merchants who developed the lex mercatoria to resolve certain disputes concerning men of commerce outside court. So we talk about all of those stuff. Then talk about the fact that around that same time, Ghana already had systems in place for resolving disputes. And these were primarily done through the chiefs, clan heads, family heads, even before the advent of the Europeans. The Europeans' introduction of the formal court system creates a false narrative that our indigenous system of resolving disputes is an alternative. Okay, but the only reason why we still consider it as an alternative is because the court system is what is recognized nationally as the means of resolving disputes. Then talk about the fact that, however, even with the adoption of the formal court system, the same problems that were seen even outside Ghana were still recognized. And then you talk about the problems from 61 to 99, which led the drive for ADR, which culminated in the passage of the ADR Act. So you can structure your answer around this. Okay. So when we speak of ADR, looking at the history, the new ADR Act, it's not really new, but let me say the new ADR Act defines ADR at section 135 as the collective description of methods of resolving disputes otherwise than through the normal trial process. Now, this definition indicates that the normal process for resolving dispute is trial, which is the court process. So any other form of dispute resolution outside the normal trial process is an ADR method. So by section 135, that is the understanding we get. Now, why is there a push for ADR? Whenever you have a question on why ADR, it is simply another way of asking you the advantages of ADR. And if you don't remember the advantages of ADR, think of the disadvantages of litigation. Immediately we are more familiar with litigation. Immediately you know the challenges with litigation, you know the advantages of ADR. Okay, so what are some of the problems with litigation that requires an
Yeah, no, I
alternative
think there's a
means
hand up.
for resolving this? Yes, Geoffrey. Yeah,
Gameli, please
Geoffrey,
go
your
ahead.
hand is up. You can ask your question.
Okay, please proceed.
Okay. So what are some of the challenges with litigation which serve as the advantages of ADR? So one of the most important issues with litigation is expertise. Is expertise. See, the problem with the normal trial process is that it is possible to have a judge who does not have any expertise in the field where the dispute has arisen between the parties. So imagine there is a dispute concerning some contracts around aviation or aeronautics engineering, something of that sort. And you take it to a normal judge who has no expertise in this field. If you are a man of commerce, you are likely to have a fear that the decision the person is going to give will not be one that is informed by a clear understanding of the area in which the dispute has arisen. Unlike under arbitration, unlike under mediation, where you may have a mediator who understands the area and will lead you or will direct you to look at those issues in resolving the dispute, you won't have this in court. So expertise is one of the main challenges with the litigation process that drives the love for ADR by men of commerce. Another one, we'll rush through this parts quickly. Another one is the protracted nature of litigation or trial, the length, okay, the duration. So trial can take a long time, but ADR processes, negotiation, two parties meet within 3 weeks, they are done. Mediation, which is another form of assisted negotiation, within 3 weeks, 1 month, 2, 3 months, we are done. Even with arbitration, that is more formal, from the inception of the arbitration, time limits will be set. So within 3, 4, 5, 6 months, you can finish with the arbitration. The arbitrator or the tribunal will give the award, and you move into enforcement or execution. Okay, so the delays with arbitration, with the trial process or litigation, informs why ADR becomes more liked by men of commerce. Another one that you can think of is relationship. Remember, the men of the merchants are common law. One of their key problems, the court system provided a win-lose situation. And by the end, it would destroy the relationship between the parties. So to prevent that, they resorted to the merchant style of resolving dispute, where they selected one person among themselves to hear their dispute. The same thing with ADR mechanisms. ADR mechanisms are usually target maintaining the relationship of the parties, especially when you consider mediation and negotiation. Even with arbitration, there is the drive to ensure that the matter is resolved in a way that protects commercial relationship. Okay, so relationship also is one of the advantages. Then publicity. Publicity. Some issues which may arise between parties, especially commercial issues, will be of a nature that the parties will not want to resolve them in the full glare of the public. And so some of these ADR mechanisms allow parties to resolve their disputes in private. Okay, for negotiation and mediation, for instance, the resolution may never be published, unlike litigation where there may be the case reported in the law report. Even for arbitration, the parties can decide that they don't want the award, that is the judgment of the tribunal, to be made public. So these things form parts of the advantages of ADR. Then there is the limited range of outcome. In the traditional litigation style of dispute resolution, there is basically only one way of resolving the dispute. One person wins the case, another person must pay compensation to him, or one person is found liable and must pay compensation. It's always about that. But ADR provides so many other possible outcomes. It can lead to a situation where the parties can agree that, okay, we will resolve the dispute by performing the contract again, but doing it in a different way. Okay, the parties can find that they have different interests, and therefore they can both pursue their interests without conflict in the form of maintaining their initial positions. So these other forms of outcomes make ADR more attractive to other people, especially men of commerce. So some of these are the reasons for ADR, why people prefer ADR and why people do not prefer the litigation process. Can also even talk about control. In most of the ADR mechanism, the parties control the process or the procedure. They determine when they want to meet, where they want to meet. Now, they can basically hear a full ADR session, whether negotiation, mediation, arbitration, on Zoom. But with the court process, there is a place, a venue that all parties must travel to. Some of these inconveniences, the loss of control over the process, sometimes make ADR litigation unattractive and ADR more attractive. Okay. But it doesn't mean that ADR doesn't have its disadvantages. ADR also will have its disadvantages. One disadvantage that people usually overlook, but is very important, is delay. Now, remember, delay is one of the reasons why people prefer ADR, because litigation can take a very long time. But delay can also be the reason why people will not prefer ADR. Think of it. If I have a clause in an agreement with you, that where there is a dispute, we will resolve by negotiation. If negotiation fails, we will try mediation. If mediation fails, then we will try arbitration, or then we will try the courts. If negotiation takes 1 month and mediation takes 2 or 3 months, let's say we go to arbitration. Arbitration takes 6 months, 7 months. After the arbitration, you now, even if the arbitral tribunal gave an award, you now have to use the court processes to enforce the award. Okay. So the ADR mechanism, if care is not taken, can also cause unnecessary delay. And so sometimes some of the disadvantages against ADR is delay, potential delays that may arise because of the lack of finality in resolving disputes, and then the enforcement of awards. Another issue is predictability. When you go through the court process, no matter how long it takes, you know at the end, the court will give judgment. So the matter will come to an end. Again, you are guided by precedents set by courts. So that serves as a form of an objective criteria by which you can assess how the case will go. You rarely have that in ADR mechanisms. Negotiation, you don't know how the person you are going to meet is going to behave. Mediation, you don't know how the person you are going to meet, because mediation is still assisted negotiation, how that person is going to behave. Even in ADR, there is the possibility, in arbitration, there is the possibility that the arbitral award may be set aside completely, and you have to go and start the whole process again. In the court process, there is predictability because you know case law, you know principles that the court is going to rely on, so you can predict the outcome of the case. Even when it comes to the length of the process, even if there is an appeal of the decision, you are certain that at the end, res judicata will apply, so the matter will come to an end. But you're not certain that is going to be the situation in an ADR forum. Okay, so issues of predictability, issues of estoppel, precedents are all some of the advantages of litigation and disadvantages of the ADR setting. So you can think of all of these. There are more to this. If you're thinking of advantages of ADR, you can think of more than what we have discussed. But if you basically try to think about why you would want to settle your matter out of court, you would have the reasons that would basically form the advantages of ADR or the disadvantages of litigation, and vice versa. Okay. So with this in mind, there are several legislations in Ghana that have recognized the problems with litigation and have therefore provided in those legislations the recourse to alternative means of settling disputes. So there are so many of them. The Matrimonial Causes Act promotes reconciliation If you look at the Free Zones Act, for instance, it states that where disputes arise, disputes may be resolved by arbitration. Okay. If you look at the Courts Act itself, Section 72 of the Courts Act, it talks about the fact that certain disputes should be resolved by amicable settlements. Okay, so it even allows the court to refer matters to ADR, where the court thinks that that would be the best way to resolve the dispute. Even in some criminal matters, when we talk about situations under Section 73 of the Courts Act, where even some criminal matters can be resolved by ADR. So there are so many legislations in Ghana now. It seems almost every legislation that is passed provides some means of resolving disputes in a non-litigation forum. So recently, the Lands Act, which was passed, contains so many provisions on resolving cases outside court. The Labor Act also has some of these provisions. Okay, but the mother act on ADR in Ghana will be the ADR Act. Okay, and if we are going into the ADR Act, let's start talking about the main or the major forms of ADR as recognized under the ADR Act. We will skip negotiation and we will start with mediation. Mediation under the ADR Act and under the general corpus of international law and international dispute resolution is simply a form of dispute resolution where the parties to the disputes are assisted by an independent third party to arrive at their own settlement. So mediation, that's why we say mediation is a form of assisted negotiation. There is a third party who only comes in to assist the parties to arrive at their own negotiated settlement. So that third party must be neutral, but he doesn't have the authority to make a binding decision. He is only an umpire or a referee going to direct the parties towards an amicable end of their dispute. So Section 135 of the ADR Act defines mediation as the non-binding process whereby the parties discuss their disputes with an impartial person who helps the parties reach a resolution. So per this definition, the key ingredients we can draw is that for mediation, one, it is a non-binding process. And I'll explain what we mean by why it's a non-binding process. So one, it is a non-binding process. Two, it involves an independent or impartial third party. Three, that third party does not have the power to make a binding order. And four, that third party assists the parties to the dispute to arrive at their own settlement of the dispute. Now, why is there the need to clarify the issue of mediation being non-binding? Just like negotiation, the process of mediation itself is non-binding in the sense that parties are not forced to mediate. And also, the mediation will not necessarily come out with a binding order. There is a possibility that at the end, the parties will have or reach a resolution of their dispute. When they do, the mediator will assist them to reduce their agreement into writing And it is only when that negotiated agreement is signed by the parties and filed in court that it becomes binding. And that is the reason why the mediation process itself is a non-binding process. The parties are not compelled to engage in mediation, and they are not compelled to have a binding order at the end. Okay. So the nature of the mediation is that the mediator does not have any binding authority to make decisions for the parties. He's simply there to use his techniques and skills to assist the parties to arrive at their own resolution of the dispute. And if they do, they will reduce their agreement into writing before they will have a binding decision. So the parties can say, okay, we think we'll resolve our dispute this way. Like one party decides not to sign any documents recognizing the agreements they have reached, the mediation process has not provided any binding decision. At its inception or at the roots, mediation is simply to allow the parties who are disputing to heal, to resolve their disputes in a way that pleases both parties. So mediation is derived from the Latin word mediare, which means to heal. So you recognize that one of the important aspects of mediation is venting, and we'll talk about that briefly. Where the parties are allowed to vent, to tell their version of the story, because it is believed that that will help the parties heal. And when there is a healing, the dispute is resolved. Okay. Now, when you think of mediation, sometimes we won't go deeply into this. When you are asked to write about the advantages of mediation, it is simply the same as the advantages of ADR. It is virtually the same. Okay. But some other advantages that mediation will have, you can talk about cost. Mediation, just like with negotiation, may not involve you paying any person, even a third party, some outrageous amount to assist you. So mediation is usually less expensive when compared to litigation or even when compared to arbitration. Okay. Now, there is a very arguable advantage of mediation. So on the exams, you have a question on mediation, make sure you state the stronger points first before you go to those which are arguable. So the stronger points will be the fact that maybe there is rapid settlement of the dispute, looking at the time. You can talk about the cost, that it is less expensive. Talk about the greater degree of control by the parties on the process. And then you can talk about the fact that it will help preserve relationships. You can talk about all of those stuff. Okay. Before you come to the more controversial advantages, one controversial advantage of mediation, which you see often viewed, that mediation provides decisions or outcomes that will be complied with by the parties. That is controversial because litigation provides a judgment of a court and an order that you must comply with. And if you don't comply with the order of the court, it will lead to serious consequences, contempt, execution, where your property can be sold to satisfy the judgment debts and all of that. The reason why people say the decisions from mediation is more likely to be complied with is that it is a more tailor-made decision, in the sense that the parties themselves, if the parties arrive at an agreement in mediation, it means they themselves have worked through their emotions, their attachments to their positions and interests, and have come out with a tailor-made agreement. And so they are more likely to comply with it in the sense that it satisfies their interests. That is the reason why we say decisions from mediation is more likely to be complied with by the parties. Okay, but it is arguable because if the parties make a decision and they don't reduce it into writing and sign, one party can decide not to comply with it. He can have a change of mind when he leaves the mediation table. And in those circumstances, the outcome of litigation will engender compliance than the mediation decision. Okay, so it is quite controversial, but it is a point that you can make on the exams and then explain it carefully. But aside that, the idea of having a customized decision is a major advantage of mediation that you don't have with litigation. With litigation, the court that determines the decision and what it wants to give to the injured or innocent party. But in mediation, the parties themselves will work out an agreement that satisfies their interest. Okay, so that customized agreement is something you get in mediation, but you would not get in litigation. Okay, but just like negotiation has some very bad disadvantages. Okay, because the third party does not have any real control over the parties, mediation can lead to one party walking away at any point in time during the mediation process. If I want to delay your time, I can say, let's resolve these disputes by mediation. We will be going through mediation for like 3 or 4 months. Then one day I just wake up and I say that, you know what, I don't want to continue again. Let's go to court. Okay, so because of its non-binding nature and because it is consensual in nature, a party can walk away at any time, and that can lead to a waste of the party time. It can also lead to delay. It can lead to a lack of control or compliance with schedule because there is a lack of procedural rules. Remember, mediation is an assisted negotiation. So the parties themselves decide when they want to meet, where they want to meet, how long the meeting should take, all of these things. There aren't any fixed procedural rules they have to comply with. And so that can be a problem. We have to meet at 4 p.m. on Saturday. At 3 p.m., one party can call that, you know what, I can't make it. So let's move the meeting to next week. But you can't do that with the court. You may not even be able to do that with ADR and arbitration. Okay, so the lack of procedural rules can be a major problem for mediation. And just like negotiation, mediation can lead to bullying when you have a hard negotiator on the other part, someone who is stuck to his position and does not want to consider the interests at play. He may say that, you know what, for me, this is what I want. So you can be in a mediation for 10 years, he will never change his position. And so if the other party wants a resolution of the dispute, he will have to cave into what? The bullying. And so there is a likelihood that the bully will win in mediation. Okay, so that is another disadvantage of mediation. Then one other disadvantage, which is also an arguable point, so when you state it, you must explain yourself very well, is cost or expense. Ordinarily, mediation should be less expensive. Ordinarily. But there is a problem in the sense that in the court system, you don't pay judges. In the court system, the government pays the judge. So at the end of the case, you don't have to pay any judge. So that expense is taken care of. All that you may have to pay for might be a lawyer or the cost of filing processes. But remember that although mediation is between the parties themselves, assisted by a third party, the parties to the disputes may be represented by lawyers. So they'll end up paying legal fees. Okay.
Jesus Christ.
So they will end up paying legal fees. Now, if that happens, mediation can be as expensive as litigation and may even be more expensive if you factor in the cost that you have to incur paying the mediator, which is something you don't have in litigation because you don't pay the judge. Okay, so in certain instances, mediation can be more expensive, especially when the dispute is in a technical area that requires expertise. You have to bring in a mediator who understands that field and can direct you guys to a proper resolution of the dispute. Securing the services of such an expert may be very expensive. So the advantage that mediation is less expensive can also be a disadvantage. But when you are citing it as a disadvantage, you must properly explain your position. Okay. So with that in mind, the main parties to the mediation are the disputing parties. But they require a third party. There must be that third party who is the mediator before we can have a mediation. Now, who qualifies as a mediator? Anybody at all. Today, you can have a problem with your friend, and the two of you will try resolving it. You are unable to resolve it. You can bring another friend or an elderly person in to help you resolve the dispute. That elderly person is mediating. Okay. So anybody at all qualifies to be a mediator. But there are professionals who have gone through training and have been certified as mediators. Okay, but generally, anyone can be a mediator. Now, to be a mediator, you need to have certain qualities. You need to have certain qualities. And so sometimes the exam question will ask you to write on the qualities of a mediator. When you are asked to write on the qualities of a mediator, you are to cite at least 5 or 6 of the qualities of a mediator. If you are going to forget any of the qualities, don't forget independence. The independence here is part of the definition of mediation because it is resolving disputes by the assistance of an independent or a non-partial third party. So one quality of a mediator is that he must be independent. He must be impartial, or he must be neutral, and he must be able to work on his own without the influence of either of the parties to the dispute. So that is one important quality of a mediator. Then remember that the Latin word translated as mediation in English, we said means to heal. So if you are a mediator, one of your primary roles at the mediation is to help the parties heal. And to achieve that, you need empathy. So one main quality of a mediator is empathy. The mediator must be empathetic. So he should be able to put himself in the positions of the party or in the shoes of the parties and understand how they feel, because that is the only way he can help the parties heal. Okay, so empathy is one important quality of the mediator. Because mediation is also under the control of the parties, a mediator must be flexible. Flexible in the sense that he should be able to adjust to unusual situations that will come up. We're supposed to meet on Friday, one party cannot make it, so he wants us to move it to Saturday morning. The mediator must be someone who has the ability to adapt to such unusual circumstances. Okay. And remember that in the mediation process itself, things would change in the sense that one party can get very angry. The mediator must be someone who must have the flexibility to be empathetic in one moment and show some form of authority to keep the people in check, to ensure the process goes on smoothly. Okay, so he must have flexibility in the mediation process. Okay, he must also be understanding. Understanding is quite similar to empathy. By understanding here means that he should be able to listen to the parties and know why they are sticking to a particular position. See, it is very important when you are in a mediation to know that this is the reason why he does not want to agree to what the other party is saying. So he should be able to hear the stories of the parties and understand them from whichever angle they are coming from and know why they are sticking to a particular position. Okay, he should understand why a party may not want to speak on a particular issue. So he must demonstrate understanding during the mediation process. Then he must have creativity. He's there to, so when we go further, we'll talk about this. But one of the main things the mediator is going to do in the mediation is to point the parties to possible factors or facts that will help them resolve their dispute. He won't make a decision for them, but he's going to guide them towards a resolution of the dispute. So he must have creativity to look at the problem the parties have brought to the mediation and generate options. Okay, generate options that the parties must consider in resolving their disputes. He should be able to do that. He should listen to the parties and tell that, okay, there are, in my view, I think there are 4 ways by which you can resolve the disputes. One is you take this angle, the other is you take that other angle. So you should be able to generate a lot of ideas or options that can help the parties resolve their disputes. And that involves creativity. So he must be creative and he must be inventive to help the parties have options that they can explore in resolving the dispute. And he must have authority. And this is a very delicate issue with mediation. Because ordinarily, the mediator does not have an authority to make a binding decision. However, he must demonstrate authority to ensure that the parties to the dispute follow agreed schedule. If you are to meet at 10, they must be there at 10. If we are meeting at this venue, they must come to that venue. So he must demonstrate some form of authority that will lead to the parties following such schedule. Without demonstrating authority, the parties will not respect him and they won't follow any made concerning the progress of the mediation. Then he must be a trustworthy person. Okay. He's someone that these guys are coming to tell their pain. And so he must be someone that they can trust. If you are a mediator and the parties can't trust you, there is no way they are going to open up during the mediation. So he must be someone who is trustworthy in the sense that he will keep the information confidential, trustworthy in the sense that he himself, he is not someone that has been that we believe is supporting one of the parties. So those matters should be settled in the minds of the parties through the dispute so that they can trust the mediator going forward. Okay. Then the mediator must have judgment. Now, judgment as used here is not that he will make a decision. It's that he should be able to employ common sense to tell when what must be done. Okay. He should be able to employ common sense to know that at this stage, it is not right for me to ask this party to tell his story because he's become so emotional. And so we should take a break. He should know that I've allowed this person to talk too much, and the other person may feel that I am taking the side of the other party. So I should let this person talk for 15 minutes, and I'll let this person also talk for 15 minutes. That is the judgment we are talking about here. He should be able to look at the situation and make decisions that will make the parties convinced that there is no bias here and that there is the possibility that their dispute will be resolved. So that is the idea of judgment. Okay. And that plays into the last quality of the mediator we'll speak about, which is his constructiveness. Sometimes he has to correct people. Okay. He will have to see the possibilities, even in the problem that is before the parties, and be able to motivate the parties that they can resolve their dispute. That is what the constructiveness is about, and it requires judgment. He should be able to look at the parties during the mediation process and tell that the way one party is going, it will be impossible to find a settlement of the dispute. But he must do that in a way that will help the parties see that he is doing it only because he wants the parties to resolve the dispute amicably. And tell them that this is the reason why I think you should not go by the approach that you are taking, and that you should look at this other option, because the approach you are taking will not help resolve this dispute, and we would have ended up wasting our time here. So it is the constructiveness. You should be able to criticize a position without it appearing that he's choosing sides, but it will lead to the parties being convinced that he's only assisting them to resolve their disputes. Okay, so when you're asked to state 4, 5, 6 qualities of a mediator, you should remember he must be an independent person, he must be a flexible person, he must have empathy, he must be trustworthy, he must be a creative person, he must demonstrate judgment, understanding. He must remember these things. And for a lot of the things under ADR, if you remember the points, you have to explain them in your own English or your own understanding. Okay. But the other important thing about the mediator is his role during the mediation. During the mediation, what is the mediator expected to do? Now, he has several functions at the mediation. Okay, there are about 15 of them, but I'll talk about the most important ones you should remember for the exams. He's the facilitator. The mediator is a facilitator. Now, sometimes let's imagine you want someone to do something for you quickly. Okay, you sometimes will give the person money or something to serve as an incentive. That money you are giving to the person will facilitate the performance of the task that you have given to the person. And it's the same thing the mediator does here. The mediator has a duty to help the parties resolve their disputes. Okay, he has the duty to help the parties resolve their disputes. And so he is the one that must ensure that that vehicle keeps running. So whenever there is something that will prevent the resolution of the dispute, he must step in or he must ensure that he takes that blockade out of the way so the parties can continue or can pursue the resolution of the dispute. So he's a facilitator of the dispute resolution. Okay. So he serves as someone who directs them, who puts in place mechanisms that will encourage them to pursue the resolution of the disputes. That is what we mean by he being the facilitator. And this may involve he listening to their story and then reframing the story. Okay, reframing the story in a way that will help the parties know that, oh, actually, this dispute can easily be resolved by you doing this and me doing that, and we'll have our interests protected or secured. Okay, so that's what we mean by the mediator being a facilitator. And it's sometimes, to the second point, sometimes the parties who are at mediation, they do not see eye to eye. They are at loggerheads. And so they may not even want to talk. The mediator's second duty is to open channels of communication. The mediator is the one that must use his creativity and his judgment to facilitate communication between the parties. Okay. Sometimes the only reason why the parties cannot resolve the dispute by negotiation is because the two of them cannot be alone in a room. So the mediator is the one whose presence will help the parties talk. So sometimes when they are talking, they will be talking to the mediator. They wouldn't be talking to the other party. The mediator's presence is what is going to help them start talking. So he's the one, or one of his primary roles will be to open channels of communication. Okay. And you realize that at the onset, the parties may not be talking to each other. So they'll be talking to the mediator directly. But as the process goes on, it will get to a point that a very conducive atmosphere will be created for the parties to speak directly to each other. Okay, so that is very important. The second duty of the mediator, or his second role or function, is to open channels of communication. The third is to act as a translator and transmitter of information. See, sometimes parties to a dispute just want to be right. So I don't want to listen to the other party. The other person does not want to listen to me. Now, because I don't want to listen, it is possible I will hear that other person speak, but I will interpret what he's saying under the lens of my bias, of my preconception. So I'll hear him, but I won't really understand what he's saying. In such circumstances, it is the role of the mediator to receive the information by the other party. Yeah, Fatah, your hand is up.
Yeah, I'm getting some interference. I don't know if it's from my end or can anyone confirm if you're getting same?
I think mine is okay.
Mine too.
Okay, then Fatah, I think it might be from your end.
All right, sure, thank you.
Okay. So
I think I also have that interference, so I'm not sure where it's coming from.
what is the interference? How is it like? Is it like a sound?
It's breaking.
The line is breaking. Oh, okay. For that, I don't know what I can do about it.
I am having a
Now.
hit in mine.
Oh, a haze. Wow. I don't know how that is happening.
Okay, you just proceed and let's see how it goes.
Okay, sure. So I was talking about the mediator acting as a translator and transmitter of information. So what he does is sometimes he will just listen to one party and then rephrase what that party has said in a way that will be understood or that will be accepted by the other party. Or sometimes party A said something, party B misunderstands completely what party A said. So the mediator was the one that was stepping in and said, oh, no, I don't think that's what party A was saying. I think what he meant is that what he wants from this meeting is A, B, or C. So you see, he translates, although the parties may be speaking the same language, they may not be understanding each other. So he would receive that information and translate it in a way that the other party will understand, or that may be well understood by the other party. That's why we say he translates and transmits information. Okay. Then he develops options. Another crucial role of the mediator. What do we mean by he developing options? Options here means options to resolve the dispute. The mediator is the one that will help the parties generate a variety of possible options to resolving the dispute. So let's say it's about a land. Wants that piece of land for a project. Yeah, I think Banks, your hand is up. Banks.
Hello. Sorry, it's mistaken. Sorry.
Oh, okay. Sure.
Pardon.
Sure. So the idea of generating options or developing options is that it's possible that the parties are both under a contract for a land, let's say with the same person. One party is saying that, you know what, I must use the land because I contracted for the land first. Another person said that, yeah, you contracted first, but I will use the land right after you. And so I expect you to clean the place up, this and this and this, so that the place will be in a good state for me to use for my program. So that can be the issue. One party that, look, you cannot force me to clean the place for you, this and this and that. All of these kind of issues arising between the parties. The mediator is the one that must listen to the parties and go like, okay, so you will finish using the premises maybe at 5 p.m. And it's possible that the place will be dirty or messy after that. One option would be that you will clean the place up right after using it so the other party can use it at 7 p.m. So that's option one. Another option will be that if you're not going to clean the place, then you will leave right after you finish at 5 so that the other person will have access to the premises from 5 and clean the place or make the place ready for his program at 7. A third option is the both of you, your workmen, will come together and clean the place after the first person is done using it. So he will develop these options for the parties and leave them to choose which of them is more acceptable to them. So when we say he's a developer of options, it means that he listens to the parties, although he's not there to make a binding decision. He's there to help the parties arrive at a resolution. So he will generate options for them that he, together with the parties, will explore and choose which of them best help in resolving their disputes. So that is one function of the mediator. He's also an agent of reality. And this is self-explanatory. He brings the parties to the position where they will realize that some of their expectations cannot be met. Okay, so some of the parties will approach the mediation with some expectation that no other reasonable person on the other side will agree to. And so the mediator is the one that will let the parties know that, look, let's be very realistic here. There is no way both of you are going to reach an agreement where you get everything and the other person does not get anything. So we must arrive at a solution where both parties at least can walk away with some bit of their interest satisfied. Okay, so he's the person that would bring this to the attention that, this thing that you are clamoring for, there is no way you are going to achieve that, or it will be impossible for you to achieve that, or it is not realistic, and build a more realistic framework for the parties. Okay. Then he's also an expander of resources. Being an expander of resources means that sometimes the dispute the parties have brought, what they need to help them resolve the dispute may not be known to them. That thing is available, but they don't know. So he's the one that will draw their attention to those other possible resources that will help the parties resolve their disputes. He will draw their attention to those sources, assist them in securing them. Maybe it's a land issue. They need a surveyor. They need a land valuer. Okay. The parties in their shouting at each other have not even thought about that. The mediator is on us that, okay, you are saying the property costs 10 million Ghana cedis. The other party said that he's not going to pay 10 million because he thinks it's 6 million. He knows somewhere he can find it for 6 million. You say, okay, you know what? So let's bring an independent valuer to assess the property, and then we determine how much should be paid. So he's an expander of resources. He brings in resources that will assist the parties to make intelligent decisions in resolving their disputes. Okay. Then the last thing I'll talk about, there are others. Okay, but the last I'll talk about is that he's an impartial convener. So he's the person that will set guidelines for the mediation and ensure that the parties comply with the guidelines. So he's not choosing any side. He will ensure that the parties engage in a civil proceedings until they reach an agreement. So being the one that will establish the ground rules on what the parties must do, and even if they reach an agreement, how they should go about reducing the agreement in rights and how it to be signed and all of that. He serves as an impartial convener. Okay. Now let's talk about the mediation proceedings, the phases of the mediation proceeding. So every mediation will commence with an opening statement. And that opening statement is by the mediator. We'll look at a sample shortly, because on the exams, sometimes you'll be asked to draft a mediator's opening statement. Okay, I don't think you have to chew any sample you have. If you understand what the mediator must do with the opening statement, you can use your own words to write a mediator's opening statement. So what is the opening statement about? That's the time the mediator introduces himself to the parties. He tells them who he is. He tells them his role at the mediation and the nature of mediation. That is, it's a voluntary process. He will talk to them about time, that they must follow schedule to help them resolve their dispute in time. He will tell them how they are to communicate going forward and how each party will have the chance to say what is on its mind during the mediation process. And it is an opportunity for him to develop a rapport with the parties to the disputes and their counsels if they have any. So the opening statement is very, very important. Now, after the mediator has given his opening statement, the next phase of the mediation is the storytelling or venting stage. And this is the stage that he allows each party to tell their side of the story. Now, the idea here is that each party will be given the opportunity to tell his side of the story without any interruption. Okay, the venting period is very important because sometimes a party to a mediation, all he's looking for is an opportunity to speak and be heard. So he must be accorded the opportunity to speak without any interruption. Okay, and that is also the time that the person speaking, the mediator, and the other party will understand the relevant issues that they are going to contend with, understand the impact of what's happened on the parties, understand how the parties feel about the issues, and then know how to create an environment that will foster communication between the parties. So here, the mediator must he must decide who is going to speak first. So he must ensure that there is an agreement on who is going to speak first. Then he must listen attentively, take notes, and then he can ask important questions to clarify facts and the feelings of the parties. Now, after the venting, the next thing is to define the problem. And here, the mediator, the purpose of this stage is to distill what the problem is, what the real dispute is. But sometimes what the parties think they are disputing about is not even the dispute between them. So after the venting, the mediator now, so both parties have spoken, the mediator now understand what the real issue is between the parties. So that Next step is to define the problem and then single out the issues and then the interests of the parties. Okay, so this is where he tells them that this is the real problem that the two of you actually have. And I think that for this problem, you guys have taken these positions and these are your interests. Okay. And he will do this by giving them a list of the issues he has seen, draw out the underlying positions and interests of the parties, then draw an agenda going forward and try to promote dialogue or communication between the parties. Now, after this, you move to the fourth stage where you search for a solution. Now, this is the stage where you have all the issues to them, the problem to them. So you are going to come out, you brainstorm on options. Remember, the mediator is what? Someone who is going to develop options. So here he brainstorm with them on options, allow them to communicate. Then they have to now choose the most viable option. But before they choose the viable option, they must come out with what? An objective criteria. What is going to be the criteria to choose the best option? So it's where they develop all of that. Then this is a stage that they will look for an agreement. And if they find one, this is the stage that they will draft the agreement. If they do so, then we move to the next stage where they finalize the agreement. So here they clarify what they have agreed on, they reduce the agreement into writing, and then the parties sign. So the mediator is the one that will ensure that the agreement contains what the parties actually agreed, and it has been written down, and the parties have signed. And after this, we close the mediation. Here he will give a closing statement where he will thank and congratulate the parties for choosing mediation. And if they succeeded, he will thank them for coming to a successful end. And if they reach an agreement, make copies of the agreement available to them. If they did not reach an agreement, direct them that they can resolve their disputes maybe by going to court, and encourage them to use mediation in the future. Okay, that is basically the stages of mediation. Sometimes they'll ask you on the exams to write short notes on the mediation process. When they do so, this is basically what they are asking you to do. Now let's look at the opening statement of a mediator. I said that you find samples around.
Yeah, hi. Yeah. Yeah, sorry, there's a hand up.
Yes, Clement, sorry, I didn't see that. Your hand is up.
Senior, please, can you give a recap of the mediation process?
Okay.
Proceeding, sorry.
So let me just mention the phases. So you start with the opening statement by the mediator, where he tells the parties why they are there, who he is, his role, and that is a voluntary process and all of that. Then after that, we go to the storytelling or the venting stage, where the parties to the mediation are allowed to tell their side of the story, okay, without any interruption. The mediator at this point will use that as an opportunity to understand what the problem is, what the issues are, okay, and how they can resolve the dispute. After that, he will now distill the issues or the problem. So he would set out the problem or list the problems or the issues between the parties to them and let them know what the real dispute is between them. So that is where he defines the problem. That's the third stage. Now, after defining the problem, they move to searching for a solution. This is where the parties together, not just the mediator together with the parties will brainstorm on options in an attempt to find an agreement. And if they find an agreement, they will draft that agreement. So that's the fourth stage. And the fifth stage is where they finalize the agreement, clarify the agreement, reduce it into writing, and then under the supervision of the mediator, the parties will sign the agreement. And the last thing will be closure. After they've signed the agreement, you close, you thank them and congratulate them on the success. If they did not arrive at any solution, you thank them for using mediation, distribute copies to them if they arrive at an agreement, and then refer them to an appointing authority, and then encourage them that they can go to court to resolve their disputes or whichever way they want to use, and then you encourage them to use arbitration later. So this is the procedure, okay, or the phases of arbitration. Clement, is that okay?
Thank you very much.
Okay. Now let's talk about the opening statement. As I said, on the exams, you may be asked to draft the opening statement of an arbitrator. And when you have this, I don't think you should cue an opening statement for the exam. Just understand the openings. It's just about 4 or 5 paragraphs. Okay. So the first paragraph is the introduction of the arbitrator and the mediator. That's where the mediator tells the parties who he is. So he tells them his name, who appointed him, and his duty there, which is to assist them, and then his background. So my name is Noah. I have been appointed by the Center for Mediation and Dispute Resolution to assist you in discussing your issue or your dispute and finding an amicable solution. Then your background. So I have worked as a mediator for the past 15 years, mediating disputes in Ghana, in the US, in the UK. So that's basically the first paragraph. Okay, that is the first paragraph. The second paragraph is where you congratulate them, thank them for choosing mediation. So you can say something like, I would use this opportunity to congratulate you for choosing mediation or for coming here today to try to negotiate your own agreement on some issues that may have been hard to discuss in the past. This is a clear indication that you want to take responsibility for making your own decisions. So that is the second paragraph. So the first paragraph, tell them about who you are, who appointed you, what you are doing there, and then your background. Second paragraph, thank them for choosing mediation and telling them it's a good step, indicating that they want to take responsibility for resolving their dispute. It's for you to tell them what is going to happen in the course of the mediation. What are you going to do there? Like the three of you, what are you going to do? So in the next 3 weeks, if it's going to take 3 weeks, tell them, the two of them, you will be engaged in negotiations in search for a joint solution that satisfies your needs and interests. My role here will simply be to help you identify your problems, your issues, and help you clarify needs that must be met by your solution. I'll also assist you to develop a problem-solving process that will enable you reach your goal for coming to the mediation. So that's what you do at the third stage. At the third stage, you are telling them that in the next weeks, they are going to find their solution themselves, and they'll do that through discussions, through negotiation. You only assist them by helping them identify the problems and issues and helping them choose the appropriate solution that satisfies their interest or their goal. That's what you do in the third paragraph. The fourth paragraph, you tell them about the voluntary nature of mediation. So you just tell them that mediation is a voluntary process. And so they are only here because they want to be here and to find their own solution. And they can walk away whenever they want to. You don't have the power to make any decision that will force them to remain in the process. You only advise them along the way as they search for a solution. And if they find or if they come to a solution, you assist them in what? Reducing it into writing and then signing. That's what you do at this stage. Then you conclude by informing them that they can go to court if they don't find a solution, but you are an impartial person without any bias, without any partiality, and you are going to help them resolve their dispute. Should they have any challenge with how you are going about the process, they should draw your attention to it and you will address it. That is simply what the opening statement of the mediation is. So if you are asked on the exams, write or draft the opening statement of a mediator. This is basically what you are doing. My name is this and I've been appointed by this body as your mediator, and I'm here to assist you to discuss your problem and issues and attempt to help you resolve your issue amicably. I'm grateful you chose mediation, and it's a clear indication by you that you want to take responsibility for the events that have happened in the past and to find your own solution in resolving these disputes. In the next 3 weeks, you will be engaged in negotiation to find a joint solution to your dispute. And my role here will simply be to assist you to recognize your problems, to recognize the issues, and clarify any misunderstanding that may come up and put you on the right path towards finding your solution. Mediation is a voluntary process, and so you cannot be compelled to stay here. You have the right to walk away at any point. And when you do, you are not barred from resolving your dispute in any other manner, like the court or in arbitration. But if you find a solution, I'll help you reduce into writing and then signed by the two of you. I am going to be an impartial person throughout the process. I don't have any preconceived biases, but should any of you have a problem with how I'm going by the mediation, you can draw my attention to it and I will address it. So basically, in your own words, this is what you have to say during the mediation. Okay. So we have spent almost 2 hours. I want us to take a 10 minutes break for myself so that I can rest my voice for about 10 minutes. Then we'll come back and talk about victim offender mediation and then arbitration. So for the next 2 hours, then we'll talk about that. Okay.
Senior, is it possible to take a few questions before we take the break? Maybe 2 or 3 questions.
Yeah, is there any question? Maybe 1 or 2 questions. Yes, Yakubu.
Thank you. So, in exam situation, is it correct to write your name as part of the opening statement, your real
No,
name, or you can use
no,
any
don't
other?
write your. Yeah, use any other name. Don't write your name on not just this ADR on any exam. So, civil procedure when you are drafting, don't use any name. Like, don't use your real name. You can formulate any name you want to use. Just that. Never write your real name on the exams.
Okay, so
I think is this Cynthia? Okay, sorry. Yakubu, continue.
yes, as part of the opening statement, can you talk about caucusing? Let's say you meet them separately when they need be and all that.
Yeah, you can talk about that in your opening statement. You can talk about caucus in your opening statement. That is if you are going to use caucus in the mediation process. Sometimes you will not use caucus, but if the process is of a nature that you will use caucus, then you have to tell them that you will be, and you say that during your disclosure, that you disclose that you are not biased and all that. You state there that at some point you will be having caucus with them, and none of the parties should interpret it as you choosing the side of one party or siding with one party. So if you are going to do it in the process, then you can state it. Okay.
Okay, so what about confidentiality of the whole process? Do you have to mention it in the opening statement?
Yes. Yes, you must talk about the fact that it's going to be a confidential process. All of that will come in the paragraph where you are talking about your disclosure. That is going to be a confidential process. Nothing that happens here will go out unless they themselves agree that it should go out. So you talk about that also.
Thank you very much.
You're welcome. Yes, Cynthia, your hand is up.
Yes, please. Hello.
Yeah, I can hear you. Please
Okay,
speak.
thank you. Please, I know parties select their own mediator, but when you were talking about what the mediator does during the process, you mentioned that the mediator was from a particular company. I want to know how is the mediator selected? Is it that they go to?
Yes, so remember that the parties themselves voluntarily will decide to use mediation to resolve their dispute. If the parties decide to use mediation, that agreement to go to mediation will state how they want to resolve their dispute. Okay. So it will say how they will choose their mediator. It will state it. Whether they themselves will jointly select, or some instances they will use an appointing authority. So there are institutions around you can call on to help you with the mediation. If that is the case, they will appoint the mediator.
Okay, thank you.
Yeah, so you're welcome. Any other question before we take our break?
Yeah, Edna, you can go ahead.
Okay, Senior, please, about the caucusing, please, you said that you don't, if you won't use it, you don't need to state it in the opening statement. So what if along the line, I realize that that's what I need to do, but I haven't stated that in the opening statement? Because I'm thinking maybe...
Yeah, in that case, yeah.
Sorry, Noah, we can't hear you.
No, she was speaking. She should continue. And I was speaking.
So I was saying, in my mind, I'm thinking you need to say everything so that in case you use it, fine. In case you don't use it, too, that's fair. But in my mind, I'm thinking in the process where I don't state it in the beginning, and then along the line I realize I need to have a caucus with each and every one of them. But then in the opening statement, I had not stated that. What do I then do? Do I now have to come and tell them that this is what I'm coming to do?
Yes, so it is done. If you look at a typical, if you've seen examples of opening statements, there are so many opening statements you won't see anything about caucus. Because in practice, it is not every mediation process that you will do caucusing. If during the mediation process you realize that you want to do caucusing, you will tell the parties that you would want to meet them individually. And then you tell them the reason why you want to meet them individually. And the parties may or may not agree. You get that? So it is not always, and the reason why, okay, practically, the reason why a lot of opening statements do not say anything about caucusing is the opening statement of the mediator may be the first time he's meeting the parties. He will not know how the parties are going to take the issue of caucusing. Caucusing is a very delicate issue in mediation. It is a very delicate issue in mediation. So he may not know how they're going to take caucusing. And remember, at that stage too, he does not really know the problem at hand. He doesn't know the weight of the problem. So he's going to use the opening statements and then listening to the parties to decide whether caucusing will be important and whether the parties will even be interested in having caucus. So that's why a lot of, even when, like you are saying, a mediator thinks that he may need caucusing in the long run, that's the reason why a lot of opening statements are silent about caucusing, because you don't know how the parties are going to take it at that time. So you want to give them the chance to know the general scope of what will go on. And if there is anything that you have to specifically do, you will bring it up. If you don't do it that way, then there are a lot of what ifs you can think about that you have to state in the opening statement. But the opening statement is just to give a broad idea of who you are, what the parts are going to do there, the nature of what is going to happen there. But the specifics will come up as the process goes on.
Okay, thank you. Thank you very much.
You're welcome. Please, is there any other question?
Okay, so last one, I'm reading from the chat box, and she's saying, please, what does paragraph 3 of the opening statement contain? So maybe if just the highlights should be fine.
So I'll say that the paragraph 3 will, and let me say this, I'm saying paragraph 3 because I'm using what I have in mind. It need not be your paragraph 3. Okay, it need not be your paragraph 3. Apart from the introduction and then maybe the next paragraph on congratulating them for coming to mediation, you can switch things around. Right after that, you can talk about confidentiality. Okay, you can talk about disclosures, the fact that you are not biased and all of, you can talk about that before you go into anything. But what I had in mind and I was talking about, the paragraph 3 is basically where you tell them what is going to happen in the course of the mediation process, that in the next 3 weeks or in the next 4 weeks, depending on the facts you have, you will be engaging in negotiation to find a joint solution which will meet your needs or interests. My role here will simply be to help you identify your problems, your issues, and provide options for you, and also to clarify your needs in an attempt to find your solution. So that is what will go into the paragraph 3. Now, when I was in law school, I think when I wanted to remember these things, now because I have said it so many times, so I remember it off about in law school, I don't think I remembered it off head as easy as I'm saying it now. But what I did was that think of it that there are about 6 or 7 paragraphs to it. And name each paragraph. Name each paragraph. So paragraph 1, you can name paragraph 1 as introduction. Paragraph 2, congratulations. Paragraph 3, you can, depend on how you want to name it, you can name it as purpose or objective. Paragraph 4, consensual process, something of that sort. So if you're able to remember the headings, the titles you have given to the 6 or 7 paragraphs, on the exams, all you have to do is, if you're asked to draft, all you have to do is write your 7 headings down. And you know what goes into the headings. So on the part that talks about disclosures, confidentiality, all of those stuff, you write what you would want to say in your own words about that. Part of the introduction, you say what you say to introduce yourself. So if you're able to remember it in that way, how it's you will easily remember. You don't have to chew someone's writing of over 1,000 words or something to just go and reproduce in the on the exams. Okay. So try as much as possible to in your studies to have them in paragraphs and title each paragraph, and you're going to remember what must go into each paragraph by simply remembering the name of that paragraph. So that is the easy way I use to remember the mediator's opening statement. Okay, so I hope that answers the question.
Hello, Senior.
Yes.
Hello. Please, a quick one about the caucusing again. Please, what if you stated it that you are going to use caucusing, and during the process you realize that you don't need it? Do you just address the parties, or how do you go about it?
Yes, so you tell the party if you stated caucus, sometimes the parties will come in all guns blazing. They are angry. You would think that this dispute, I might need caucusing to resolve it. But later I realize that after a few sessions, the parties have come to an amicable settlement. And so you don't need caucusing. As simple as that. You tell them that you had initially planned on meeting them individually to resolve this, but their conduct throughout the proceedings has shown that they want to resolve the dispute in an amicable way. They want to avoid all of these confrontation stuff. And so there is no need to even use caucusing. So ordinarily in a mediation process, you see the phase we spoke about, the closing, which is like when you close the mediation. At the closing too, there is a statement. Although in class there isn't much focus on the closing statement, and so you are not asked to draft closing statement. But at the mediation itself, there will be a closing statement where the mediator will tell them. That's why he would congratulate them for coming to an amicable settlement, tell them explain certain things that he thinks they may have misunderstood. So like the caucus, you explain to them that, initially I thought we would need caucus to resolve this dispute, but we didn't have the caucus because of this and that. Because if you tell them you do caucus and you don't do it, and you don't draw their attention to that you did not do it, one party may think you met the other party and you did not meet him. So in your closing, you must tell that although I said I would have used this process to resolve the dispute, really end up using it because we resolve the dispute without the need for it. Okay, so you have to tell them. Please, do you get it?
Yes, please.
Okay. Is there any other question? If not, then we take our break now. It's 9:08. So let's say by 9:20, we should be back to look at the victim offender mediation and then arbitration. There's talk about arbitration. So let's return at 9:20 to start that. Okay.
Great. Thank you so much. So, colleagues, you can just be online. No need to log off. Just mute for 10 minutes and then we'll get back to the session.
Okay, so I think we can resume the discussion if that is okay.
Friends, can you kindly alert the others that we have resumed the discussion so they can join? No, if you can give us about 2 minutes. I think some people love that.
Okay.
Senior, please, we can proceed.
Okay, so let's start with the victim offender mediation. So this is a form of mediation generally. However, it is mediation for certain or for some form of criminal acts. And the idea is that for certain offenses which are not very serious, the normal court process may not be the best way to dispose of such issues. And so victim offender mediation provides a way to restore the broken relationship that may have arisen as a result of the criminal conduct of the offender. So in some instances, victim offender mediation is referred to as transformative justice or restorative justice. And they are usually used interchangeably, but it is essentially the idea that certain criminal offenses must be resolved outside the normal criminal justice system because there are certain kinds of offenses that destroy relationships, and in some instances the best way to appease the victim is by bringing him or her face to face with the offender. Now, the legal basis for victim offender mediation can be gleaned from Section 73 of the Courts Act and Section 64 of the ADR Act. Now, when you read Section 73, it says that any court with criminal jurisdiction may promote reconciliation, encourage and facilitate a settlement in an amicable manner of any offense not amounting to a felony and not aggravated in degree on payment of compensation or other terms approved by the court before which the case is tried, and may during the pendency of the negotiation for settlement stay proceedings for a reasonable time. In the event of settlement being enforced, shall dismiss the case and discharge the accused. Now, Section 73 of the Courts Act providing for some out-of-court settlement for criminal matters is different in its approach when compared to Section 64 of the ADR Act. You see, Section 64 of the ADR Act says that a court before which an action is pending may at any stage in the proceedings, if it is of the view that mediation will facilitate a settlement or part of the matter in dispute, refer the matter or that part of the matter to mediation. So whereas Section 64 is emphatic on the means of resolving a dispute, here being mediation, Section 73 of the Court Act does not really state the procedure for resolving the dispute. But the reason why the two of them are usually used as the basis for victim offender mediation is that Section 73 of the Courts Act grants courts with criminal jurisdiction to look beyond the court system if there is a real of court system may address the issue, resolve the issue better. And it says that for this to occur or to use this in criminal matters, the offense must not be a felony. You must remember that. The offense must not be a felony or must not be aggravated in degree. So a felony or an aggravated offense cannot be resolved through mediation. Those are barred from mediation. So for offenses which are not felonies or which are not felonies and are also not aggravated in degree, it can be resolved by ADR, by mediation, or by any other ADR mechanism if the court thinks that will be the best way to resolve the matter. But as I said, that is different from 64. 64 is talking about all forms of matters, whether criminal or civil. But for victim offender mediation, even when we situate it within criminal matters, it is for circumstances where the court thinks, at whatever stage the court has reached, the court thinks that mediation will be a better way of settling the dispute. Now, where victim offender mediation is used the court may dismiss the case and discharge the accused. Now, a lot of times people read this and say that that means victim offender mediation, whenever it is used, the matter will be resolved completely out of court and there will be no conviction of the offender. That is not true. A combined reading of section 73 and 74 makes it clear that using an out-of-court settlement of a criminal dispute will not necessarily mean that the matter will be resolved completely out of court. The court can say that, you know what, in this circumstance, there is a bit of it that I think should be resolved by mediation. The court can allow that to be done, but it doesn't mean that the court cannot proceed to convict the accused person or the offender. But if that is the case, why is this necessary, or why would the court use or order victim offender mediation? Now, there are so many reasons, but the most important reasons can be summarized in 3 arguments. When you look at our criminal justice system, the first challenge with it is that the sufficient evidence, they can proceed without the cooperation or the participation of the victim. So the criminal justice system does not provide any relevant role for a lot of circumstances. The outcome of the criminal case will leave a lot of people dissatisfied. It can leave the victim dissatisfied. It can leave society dissatisfied. It can leave even the accused person dissatisfied. So victim offender mediation steps in when necessary to allow a more satisfactory way of resolving the dispute, by which the parties, the stakeholders to the case, are allowed to resolve the disputes, the hurt feelings, in a more satisfactory way. So the first reason is the unsatisfactory nature of our criminal justice system. Okay. The second argument is that not all offenses by their nature require the conventional criminal trial methods for their resolution. And that is the reason why the Courts Act, as Section 73, takes out those offenses which are aggravated or which are felonies. Certain minor offenses, like let me say assault, okay, an offense that the parties do not really, essentially do not gain anything if one party is convicted and sentenced. So in those circumstances, the matter may best be resolved by the parties coming face to face and talking about how the victim is hurt by what was done and how the offender is sorry for what's happened. But there are some offenses which cannot be properly disposed of by recourse to the conventional trial methods. And as such, victim offender mediation provides a better avenue in making or in resolving this dispute. Okay. The other one, the other thing we can talk about is that the victim offender mediation provides an avenue that prioritizes the restoration of relationships which are necessary in the circumstance, which are necessary or more important than the conviction of the accused person. So think of it this way. A father beats his child, and let's say it goes overboard a little. Sometimes imprisoning that father will do more harm to the child than using mediation to resolve the dispute. And so in such circumstances, the court can look at the facts and go like, you know what, let's use mediation to know why the father is doing that to the child and then attempt to resolve it so that the child can be properly taken care of. Okay, so it's an avenue that is called restorative justice to restore certain relationships that are necessary and more important to the interest or the best interest of the victim than a conviction. So when you think of the rationale for victim offender mediation, the three things you should think about will be the unsatisfactory nature of our criminal justice system, the fact that certain offenses are so trivial that the conventional trial methods are not the best means for disposing them of. And then the third thing is that in some circumstances, restoring the relationship between the parties will serve the victim better than the conviction of the accused person. Okay. So we have recognized that crimes begin by harm caused to an individual. And so the best form of justice must be one that properly compensates, not in the form of money, but properly provides for the best interest or the satisfaction of the person who has been harmed. Our current criminal system does not really care about the interest of the victim. It is more concerned about satisfying the general public by convicting or maybe sentencing the accused to custody. Okay, so you need to have these three important points in mind. So the argument for victim offender mediation is that, one, it recognizes the injury to the individual victim. And recognizes the role the offender can play in healing the victim. And as a result, both the accused and the complainant must have equal participation in the justice system. In the normal court system, it is the accused person who has a chance to be in court. The victim may not be heard in court throughout the trial. But victim offender mediation is saying that the accused must be given the chance to participate in his own healing. And then the punishment or the sanctions for offenses should look beyond compensation, should look beyond restitution, and include apology and atonement by the offender. So sometimes all the victim needs is an apology. Sentencing the accused person will not do anything for the victim. Okay, so these are some of the bases the victim offender mediation. And its advantages derives from the legal rationale. If you are thinking of the advantages for victim offender mediation, one, it grants the victim the opportunity to participate in his own healing or in the offense committed against him or her. Two, it can help decongest the prisons. If a matter is best resolved by mediation, why would you want to sentence a person to prison? So it helps in decongesting prison. And it can also help prevent retaliation. And this is very important because if you sentence a person to 3 years in prison and the person returns to society, society may not accept him and the person he offended may retaliate even though he's gone to prison. But through mediation, if they understand why the other person did it and the other person understands how he hurts the victim and they're able to resolve it, the victim and the offender can easily reconcile and the offender can be reintegrated into society more easily. Okay. Another thing is that it enables the offender to assume responsibility for his action. It brings the parties face to face, and therefore the offender will get the chance to apologize, acknowledge, assume responsibility for what he has done, unlike in the ordinary criminal justice system. And one other important thing, it can, because of how private it is, it can save the parties to the dispute the risk of washing their dirty linen in public. Look, not all offenses are of a nature that people really want everyone in society to hear about. Okay, it's not every offense that people would want that. So victim offender mediation will allow the victim and then the accused, for instance, to be in a closet where what actually happened can be talked about outside the view of the public. And obviously, it also reduces the workload of the court. The court can dispense with these matters through mediation and focus on the most important or more serious offenses. So that is the idea that we need to have for the victim offender mediation. Usually, you get a question on victim offender mediation in the exams. And the question will simply want to discuss the legal basis. Why are Ghanaian courts able to use victim offender mediation for criminal offenses? So you must remember your section 64 of the ADR Act and section 73 of the Courts Act and talk about what they say and how courts can use victim offender mediation to resolve certain criminal disputes. Then talk about the rationale. Why is it necessary? So the three main things we spoke about, those are the things you have to remember for a person on victim offender mediation. If you do some of the past questions, sometimes in a year, that's one ADR paper. They can ask 3 questions on victim offender mediation. It's a very common area they ask questions on. And as I'm saying, the relevant areas you need to know for exams are the legal basis and then the underlying rationale for victim offender mediation. If you remember these, you are good to go. You will be able to answer any question on victim offender mediation. And sometimes they will put it in the form of an essay and ask you, the question will be something like, a lot of people have spoken about the dissatisfaction with the normal court's trial for certain criminal offenses. However, there is also maybe skepticism concerning using alternative dispute resolution mechanism for resolving dispute. Under Ghanaian law, make a case for or against the use of ADR mechanisms in resolving certain criminal matters. That can be the question. And this is an essay. So you have to write on victim offender mediation, the legal basis for it, the advantages for it, and maybe in your mind, what do you think are some of the disadvantages? Okay, someone can argue that people getting the chance to go through the back door and not serving the statutory sentence for the offense they've committed may cause people to commit more offenses. It may not change the person, like those kind of arguments. But essentially, that's what the question will be demanding from you. Okay, it is a hot area. So in your revision, please pay attention to victim offender mediation. Now let's go straight to arbitration. Now, it is
Yeah, hi, Senior.
9:47. So
Michael,
yeah, Michael, your hand is up. So please ask your question.
whose hand is also up. Michael, please go ahead. Hi, Michael, if you are speaking, we can't hear you, so you need to unmute. All right, Yakubu, please go ahead.
Okay, thank you. So, the legal basis. Can you add the case, the disclosure and case management conference under the practice direction section 16, where during CMC the court may refer the victim and the offender to mediate. Can you add it?
Come again. Come again.
The
Come again.
practice
I couldn't
direction.
hear you. I don't know if it's from my end. Yes.
Okay. I'm talking about the practice direction on case management.
Yes.
Section 16. Where the court can ask the victim and the offender to go through the process of resolving their issue out of the normal trial. That's one of the
Yes.
legal
So
basis.
you can talk about that. You can talk about that. But my concern with citing that is the practice direction is not really, should I say, it's not really law in the sense that it does not grant the courts the authority per se, like the statutes do. Okay. So if you are going to cite the practice direction, you can use it as an additional point to say that the utility, let's say in victim offender mediation, is also recognized by the practice direction, and then you go ahead and talk about it. Okay. But as the legal basis per se, the practice direction on its own does not provide a legal basis, because you have to know the role of practice directions. Practice directions do not create law. They provide procedure by which something recognized by law or an authority recognized by law should be exercised. So the courts derive their authority to do what we are talking about under the various laws we mentioned, the Court Act and then the ADR Act. Okay. But the practice direction is only saying that at this stage in the trial, the court may allow the parties to attempt an out-of-court resolution of their disputes. You get the point I'm making. So it does not really create the basis for it. So if you are citing it, cite it after you have stated the two main things you are talking about and said that the practice direction confirms the need for victim offender mediation in certain circumstances and provides the procedure the courts will adopt or the stage the courts will adopt in recommending victim offender mediation. Yakubu, would you get that?
Yeah, I got it. Thank you so much.
Okay. So now let's go to arbitration. As I said, because of our time, I will skip certain parts of arbitration that will not appear on the exams. So I will skip those parts. But the first thing we need to know is what arbitration is. And there are several definitions of arbitration. So I'm showing your manual in your books. You will see some definitions by certain writers. But when we speak of arbitration, we are basically speaking about a process which is regulated by law, by statutes, by which a neutral arbitrator, privately chosen by the parties to the dispute, listens to the parties' case and renders a legally binding and enforceable award. So the indices of arbitration is that, one, it is a voluntary mechanism. The parties themselves agree to submit the dispute to arbitration. Two, arbitration is also regulated by statutes. Three, it requires a neutral third party. And four, that neutral third party makes a binding and final award. Now, in some of your textbooks, it will say that arbitration outs the jurisdiction of the court. It is a wrong position. Arbitration does not oust the jurisdiction of a court. Arbitration will postpone the jurisdiction of the court. The reason why people say it outs the jurisdiction of the court is that where there's an arbitration clause or agreement, the courts will usually not hear the case or ask the parties to go to arbitration. But the reason why it doesn't oust the jurisdiction is also that even where the parties have an arbitration clause or agreement, they can still decide to circumvent it and come to court, and the court will hear the case. So arbitration does not oust the jurisdiction of the court. It postpones it, okay, until the parties decide that they may not want to use they may not want to use arbitration anymore, and the courts jurisdiction will now mature to hear the dispute. So, what are some of the characteristics of arbitration? As I mentioned, it is consensual. It comes out with a final binding award. There is an arbitrator appointed by the parties, and it is also a private procedure. Advantages and disadvantages. We know these things already. Arbitration ensures confidentiality. Arbitration provides expertise because where the parties decide to resolve their dispute by arbitration, they can choose an expert, something that is not present in normal litigation. Okay, the control over the process, that is the procedural informality, also is an advantage. Okay, then it is more speedy, there is no delay, and finality. And when an arbitral tribunal gives an award, it is final and binding on the parties. Although there are circumstances where you can set it aside, setting it aside is very difficult. So it has some finality. Then you can say it is cheaper. But you see, as I mentioned earlier, cheaper and it's being speedy are controversial because arbitration can be very, very expensive. When you are picking 3 arbitrators who are experts in a field and are going to sit for 6 months, 7 months, or a year, sometimes the amount you're going to pay them will be more than what you spend in court where you don't pay the judge. Okay. So the major advantages are the confidentiality, the expertise that you will get, the finality, and then the procedural informality. The other advantages are debatable, such as it's being cheaper or it's being speedy. Because as we mentioned earlier, ADR processes can delay and arbitration can really, really, really delay. Okay, because arbitration is very similar to litigation. So people say that arbitration is informal litigation or it's an out-of-court litigation. It has rules by which you file processes, your statement of claim, your counterclaim, your defense. It has those processes. So it is also somehow formal, even though not as formal as the litigation process. Okay. Then what are some of the disadvantages of arbitration? Obviously, one would be the fact that it does not allow for the development of the law. Arbitration decisions do not really create precedents, and so they do not allow the development of the law, which will create certainty of legal principles. As I said, it can be more expensive and it can delay. Those are also disadvantages, but I have to explain them in their context if you use them. Then the arbitrator or the tribunal will lack jurisdiction to make certain interlocutory orders. So though you are before an arbitrator, when interlocutory orders have to be made, you must make an application to the court, in Ghana, the High Court, for an interlocutory order. So the lack of interlocutory order authority by the arbitrators are also some disadvantages to arbitration. Okay. Now let's talk about some key concepts under arbitration. Let's start with the concept of an arbitration agreement. So there cannot be an arbitration unless there is an arbitration agreement or an arbitration clause. What is the difference? It is a clause if the reference to arbitration is contained in the same contractual document. So the main document that's established the contract between the parties has a clause stating that dispute will be referred to arbitration, then it is an arbitration clause. It's an arbitration agreement if there is a separate agreement that contains the reference to arbitration. Okay, so that is different between an arbitration agreement and arbitration clause, but they have the same effect. Where there is an arbitration clause or an agreement, it means the parties have decided to resolve their dispute by Section 2 of the ADR Act provides that you cannot have an agreement to arbitrate orally. All agreements for arbitration must be in writing. Okay, it must be in writing. And the writing must indicate that the parties want to resolve their dispute through arbitration. So on the exams, if you see a question where the parties orally agree to resolve their dispute by arbitration, there isn't a valid arbitration clause or agreement. Okay, however, the arbitration agreement can be made at the time of the contract or at the time of the dispute. So an agreement, so that's a contract between parties, may not contain an arbitration clause, but after the dispute arises, the parties can agree to resolve their disputes by arbitration. That's why we say that the arbitration agreement is to submit present or future disputes to arbitration. You can have it at the time of the contract, but it can also be present when the dispute. Concerning the arbitration agreement being in writing, it does not mean that it must be contained in a single document. So when you look at Section 2, subsection 4, it says that an arbitration clause or agreement can be deduced from the exchange of written communication between the parties, either through letters, telex, email, which so far it provides a record of an arbitration agreement. So what does it mean? So it can be that I send an email to you saying that when there's a dispute concerning this agreement to be resolved by arbitration, and you send an email saying, yeah, you agree to it. We have an arbitration agreement. Okay, so the arbitration agreement can be gleaned from exchanged correspondence between the parties. Okay. Also, where there is a contract between the parties, and it does not really state that they'll resolve their disputes by arbitration. However, after a dispute arose and one party commenced a court action, the other party, so either of the parties, stated that there is an agreement between them to resolve their disputes by arbitration, and the other party does not deny it, the court will conclude that there is a duty disputes by arbitration, and they have to go and resolve the dispute by arbitration. So let me give an example. I have a contract with someone. Maybe the contract does not expressly state that disputes will be resolved by arbitration. So I commence an action against the other party when there was a dispute. In the sense of defense, the other party says that we have a duty to resolve our disputes by arbitration. And in my reply, I do not dispute it. It will be taken to mean that there is a written agreement to resolve our dispute by arbitration. So in a nutshell, Section 2 of the ADR Act is telling us that there cannot be an arbitration, a recourse to arbitration, unless there is an arbitration agreement. And generally, arbitration agreements must be in writing. Being in writing means it can be in a separate arbitration agreement or an arbitration clause, or it can be gleaned from the exchanged written correspondence between the parties. However, where there is no express arbitration agreement between the parties, but in the exchange of statements of claim and defense, one party alleges the existence of an arbitration agreement and the other party does not deny it, deduce or who infer that there is an arbitration agreement between the parties. Okay, so that is what we need to understand when it comes to the arbitration agreement. Now, let's talk about another principle, which is the concept of arbitrability. The concept of arbitrability may be the most important concept under the law of arbitration. And it has two aspects. But first, let me explain what the concept means. The concept of arbitrability means that it is only disputes that are arbitrable that can be resolved by arbitration, or that can be brought before an arbitral tribunal. So let me take it again. Only disputes that are arbitrable, that means they are capable of being resolved by arbitration, that a party or parties are allowed to bring before the court. Now, whether or not a dispute is arbitrable will depend on two questions. One is we have to look at Section 1 of the ADR Act. The ADR Act tells us that there are certain specific disputes that cannot be resolved by arbitration. So they are not arbitrable in any way. One, matters of national or public interest. Two, environmental issues. Three, interpretation or enforcement of the Constitution. Interpretation or enforcement of the Constitution. Four, any other matter that by law cannot be settled by ADR. An example would be a felony, an aggravated offense like we saw earlier. So these matters, they are not arbitrable. So sometimes the IEC question will simply give you a fact pattern, the matter went to arbitration, one person did not participate and is challenging the award that was given, and the disputes revolve around one of these issues, whether it was an environmental matter, matter of public or national interest, enforcement of the Constitution, some serious criminal offense like a felony that cannot be resolved by ADR. So these disputes are not arbitrable, or disputes affecting these things are not arbitrable. So the first thing about arbitrability is the dispute, one that is allowed under law to be resolved by arbitration. And you have to always remember your Section 1. Then two, another way to determine arbitrability is from the agreement itself. That is arbitration agreement. In whether it's an arbitration agreement or an arbitration clause, it will state the nature of disputes that should be resolved by arbitration. And as a lawyer, when you are drafting arbitration clauses or arbitration agreements, you must pay particular attention, because the way an arbitration clause or agreement may be drafted can mean that not all disputes arising under that contract will be resolved by arbitration. And let me give you an example. The arbitration clause in the contract states that where there is any dispute arising under this contract, the parties agree to resolve the dispute by arbitration. This means every dispute is arbitrable as far as it's under the contract, unless it is not made arbitrable by Section 1 of the ADR Act. But the clause can also say that disputes concerning delivery, payment, and a party's obligation under the contract shall be resolved by arbitration. So delivery, payment, and a party's obligation under the contract. Here it means that where there is a dispute concerning, let's say, a breach of the contract, it may not be arbitrable, because the clause did not cover disputes concerning breach of contract. And therefore, under that contract, disputes concerning breach are not arbitrable. So the trick is, I think my time on the exams, we had a question like that, where the IEC gives you an arbitration question in the form of a fact pattern, and then they will say maybe write on some of the principles of arbitration. You must remember the concept of arbitrability and ask yourself whether the disputes the parties had was arbitrable. And whether or not it's arbitrable, you must look at it under the lens of one, Section 1 of the ADR Act, and two, the arbitration clause or agreement itself. Does the clause or agreement cover that particular dispute? If it doesn't, then the dispute is not arbitrable. So please have that in mind. Another principle we will talk about is the concept of party autonomy. Arbitration is basically contractual. That's why the reference to arbitration must be by an arbitration agreement. And some of the foundational principles of every contract, that there cannot be a contract if there isn't party autonomy and freedom of contracts. Okay, so when you read Section 2 of the ADR Act, which we have looked at already, it grants the parties the freedom that they must consensually agree to submit their agreements, their disputes to arbitration. Okay, and that is also the reason why a lot of the provisions under the ADR Act say that subject to the agreement of the parties, subject to the agreements of the parties. So one major principle under arbitration is party autonomy. The parties must voluntarily agree to submit their disputes to arbitration. And that consent is given when there is an arbitration clause or an arbitration agreement. So let's talk about the concept of separability, or some textbooks call it severability. In the past, I've realized that it is one of the most asked about questions on the exams for ADR, and students sometimes misunderstand the concept of separability. The idea of separability is simply that the arbitration agreement or clause and the substantive agreement between the parties, what I'll call the contract, are two distinct agreements, so that where the substantive agreement is invalid or is challenged, or its validity is being challenged, it does not affect the recourse to arbitration. Now, when you read the common law history of separability, separability has only one purpose. The purpose of separability is to prevent a situation where a party who wants to resolve a dispute can circumvent going to arbitration and go to court by simply alleging that the agreement is invalid and therefore the arbitration agreement is also invalid. So separability says that even when you are challenging the validity of the substantive contract, the proper court to determine whether or not the substantive contract is valid or invalid must be the arbitral tribunal. Why? Because both parties agree to resolve their disputes by arbitration. So we won't allow you to say that because you are challenging the validity of the substantive contract, the arbitral tribunal is also, its validity is also being challenged. No, the two contracts are distinct. And as I said, the only purpose historically was to protect the jurisdiction of the arbitral tribunal. That is what separability is about. Okay. But it does not mean that at every circumstance or in every situation where the validity of the substantive contract is challenged, it won't affect the arbitration agreement. And that is the problem I've had with almost all the people, including the person who taught there when I was in Ghana School of Law, about their critique of the Supreme Court's decision in the Balkan Energy case. Because if you read any good textbook on ADR or arbitration that talks about the concepts of separability, it will give you exceptions, circumstances where both the substantive agreement and the arbitration clause or agreements will be invalid. Some of these examples was when there was a challenge about the existence of the arbitration agreement, of the substantive agreement. The independence of the arbitration agreement from the substantive agreement does not mean that there can be an arbitration agreement without a substantive agreement. You must remember that, you must know that. The arbitration agreement only comes into existence because there is a substantive agreement. I can't have an agreement with you to resolve our disputes by arbitration when we don't have a contract for which there can be a dispute that will have to go to arbitration. Okay, so the concept of separability only is saying that where there is an agreement between the parties, so there must be the substantive agreement. And that agreement provides that disputes will be resolved by arbitration. Then, if you challenge the validity of that agreement, it will not affect the reference to arbitration. But where the person is challenging the existence of the substantive agreement, you cannot say that there is a valid arbitration agreement, so that dispute must be resolved by arbitration. So that is one of the exceptions when a person is challenging the existence. So, for instance, I'm saying that there is no contract between us. The contract was that maybe it was premised on the occurrence of an event. That event never took place. So there is no contract between us. Okay, the contract never materialized. You cannot say that if you have a dispute, you are saying that the contract materialized, that will be resolved by arbitration. No. That dispute does not save the arbitration clause. So separability must be understood to mean that where there is an agreement between the parties, then even if someone is challenging the validity of that agreement, it won't affect the separate arbitration agreements. But this does not apply when you are challenging the existence of an agreement. And the Supreme Court in Balkan Energy did not state it specifically, but that was the rationale in the court saying that the of separability did not apply in the Balkan Energy case. So for the sake of exams, because usually they ask questions about Balkan Energy, let me explain this briefly. One, the Balkan Energy case, that's Balkan Energy versus AG, wasn't before an arbitration tribunal. It was before the Supreme Court. The Supreme Court's duty is to determine whether or not there was a contract between Ghana, the government of Ghana, and Balkan Energy. And to determine that, the only law the Supreme Court had to concern itself with is the Constitution of Ghana. Now, the Constitution of Ghana provides that where such agreements are signed, it must be ratified by Parliament before they become valid, effective, or before they will exist. Thus, it will be recognized as being in existence according to our Constitution. The issue before the Supreme Court in the Balkan Energy case was whether or not there was a contract between Ghana, the government of Ghana, and Balkan Energy. And the Supreme Court can only determine that question by looking at whether or not there was compliance with the constitutional process. Whether or not there was compliance with the constitutional process. Okay. In this circumstance, that contract was unconstitutional. The Supreme Court cannot say that the contract between Balkan Energy and the government of Ghana was unconstitutional. However, the bit on reference to arbitration was saved, even though it's unconstitutional. In the eyes of the Supreme Court, so far as the substantive contract never came into existence, because it not follow constitutional standards, the arbitration agreement also never came into. And who thinks the Supreme Court in Bangladesh is thinking as an arbitrator or thinking in the form of arbitration, but it's not thinking within the confines of the Supreme Court's jurisdiction. The Supreme Court was not called upon to determine a question of arbitration. The Supreme Court was called upon to determine the constitutionality of a contract between Ghana and Balkan Energy. And so in those circumstances, the principle, the doctrine of separability did not apply. where the contract never came into existence. Balkan Energy and Ghana's contract never came into existence in the eyes of the Constitution. And therefore, another clause in that agreement that says dispute must be resolved by arbitration did not come into effect. And sometimes, whether those people who make that argument are saying the Supreme Court should have said that it does not have jurisdiction to determine the constitutionality or otherwise of the contract, and that the matter must go to arbitration. Because if you are saying the Supreme Court should save the arbitration agreement, then the Supreme Court should say that the matter, it doesn't have jurisdiction, so the matter must go to, or it's staying proceedings, the matter must go to arbitration. And that is clearly not acceptable. And that is the reason why, although the Supreme Court ruled the way it did, when Balkan Energy brought the matter before an arbitration tribunal, an international arbitration tribunal, which did not care about Ghana's laws, that tribunal ruled against Ghana, and Ghana had to pay. Okay, so the reason why the Supreme Court held that way in Balkan Energy was because of its jurisdiction, its duty, the question that was presented to it. If it was an arbitration tribunal, it would save the agreement because the arbitration tribunal would not say the agreement did not come into existence. It came into existence because it was signed. Whether or not Ghana followed our constitutional standard before or after we signed agreements, Balkan Energy does not care about it. They shouldn't care about it. So an international arbitration tribunal will enforce the agreement. But a Ghanaian court like the Supreme Court could not be called upon to enforce the agreement. So you need to understand that the concept of separability, although it allows the arbitration tribunal to hear a dispute even against the validity of the substantive agreement, it is not without an exception. And one of the exceptions, or the notable exception, is where the arbitration, the substantive agreement never came into existence. Okay, think of it. There are two agreements. One is the arbitration agreement. The other one is the substantive agreement. You send me the arbitration agreement, I signed it. You send me the substantive agreement, I didn't sign it. So there is no contract between us. You are saying that because I've not signed it, you are suing me. And you say that the arbitration tribunal must have jurisdiction. Which jurisdiction is it going to exercise? Over what? Over an agreement that never came into existence. And that's why at common law, separability is not allowed where the arbitration, the substantive agreement never came into existence. Now, closely related to separability under Section 3 of the ADR Act is the idea of competence, which is captured under Section 24 of the ADR Act. Competence is a general principle of law that a court is competent to determine its own jurisdiction. So under arbitration, competence gives an arbitrator the power to determine challenges concerning his jurisdiction. So whenever there is a case at arbitration and one party alleges that the tribunal does not have jurisdiction, that party cannot just go to court. So far as there is a valid arbitration agreement, if you say the tribunal does not have jurisdiction to hear that matter, you must make that objection before that same tribunal. Okay. Now the idea is that the arbitrator is the best person to determine questions of his own jurisdiction. And so when there is any dispute concerning the jurisdiction of the arbitrator, let the arbitrator decide it. And you see under section 24 that unless otherwise agreed by the parties, the tribunal, that's the arbitral tribunal, may rule on its own jurisdiction in respect of the existence, scope, or validity of the arbitration agreement, the existence or validity of the agreement to which the arbitration agreement relates, that's the substantive agreement, whether the matters submitted to the arbitration are in accordance with the arbitration agreement. These are all to be determined by the arbitrator or the arbitral tribunal. Now, when can you object to the jurisdiction of the arbitral tribunal? The law is that you must do so, you must object to the arbitrator's jurisdiction before you take a first step in the proceedings to contest the case on its merits. So if you are the plaintiff, once you filed a statement of claim, you have accepted the jurisdiction of the arbitral tribunal. If you're a defendant and you don't object after you receive the plaintiff's plaints and you file a defense, you have accepted the jurisdiction of the court. Okay, so you must make that objection before you before you file any step to contest the case on its merits. However, if during the arbitral proceedings, the arbitrator is taking a step that you think is outside the scope of his jurisdiction, you can raise an objection to it. In those circumstances, you must raise the objection immediately. And here too, the arbitrator will be the person to decide whether or not it has jurisdiction. If the arbitrator decides that it has jurisdiction and you are still aggrieved, you can apply to the High Court by a to the other party for the High Court to determine whether the decision by the arbitrator that he has jurisdiction is actually valid or is actually acceptable. So that is the idea of competence. These are the things you may be asked to write short notes on. Now let's talk about the amiable compositeur. Let's talk about the amiable compositeur. Now, unless the parties expressly prohibit, the tribunal can resolve the dispute by recourse to principles of equity or fairness, principles of equity or fairness, which may not be expressly stated in the arbitration agreement. So the concept of amiable compositeur is that the law on which the tribunal will rely to resolve the dispute may not be only the governing law. So in the arbitration agreement or the clause, it will state the governing law. And the governing law will be maybe the law of Ghana, the law of this. But where the tribunal sits, the tribunal may, in addition to the governing law, apply the principles of equity or fairness to resolve the dispute. It is similar to the concept of ex equo e bono. Now, in arbitration, the position is that amiable compositeur or ex equo e bono is an indication that the tribunal will not be bound by formalities, so that if applying the strict standard of law will lead to a result that is unfair, the tribunal may move away from the strict application of the law and apply principles of equity or fairness in resolving the dispute. That is what ex equo bono or the amiable compositeur means. And when courts or tribunals, such as arbitral tribunals, apply it, that is essentially what they are seeking to do. There is one area under the ADR Act that we usually get questions on, and that is section 5, section 6, and then section 7. So you must know and understand those provisions very well. They cover reference to arbitration by a court and then reference by a party. So let's start with section 5. Section 5 is saying that if there is an arbitration agreement between parties to a dispute, then a party to that dispute may refer the dispute to any arbitration institution or an arbitrator or the ADR center that was established under the law, under the act. I think recently the AG established one. Okay, so section 5 allows a party to a dispute to refer the dispute to arbitration so far as there is an arbitration agreement. He can refer to arbitration. Now, section 6 is saying that if there is an agreement and the party to the dispute decides to file an action in court, the other party, at the time he's entering appearance and on notice to the other party, will apply to the court to refer the case to arbitration. So sometimes the procedure here becomes cumbersome, but this is what it means. If I have a contract with Fatah and there is a dispute and I sue in court, if we have an arbitration agreement, Fatah must not say that, oh, we have an arbitration agreement, and so what you have done in court, I won't even mind you. If Fatah is served with the court process that have commenced action, Fatah must enter appearance. At the time he's entering appearance, he must enter a conditional appearance. And you know your civil procedure already. When you enter conditional appearance, you must follow with what? A motion to set aside the rates. But here, the difference is this. When you enter that conditional appearance, you won't apply to set aside the rate. You apply for stay of proceedings, because, as I mentioned earlier, arbitration does not house the jurisdiction of a court. So the court you have sent the case to, it has jurisdiction to hear the case. The fact I have an arbitration agreement does not mean it does not have jurisdiction. It still has jurisdiction. So when the other party here, in the case I have with Fatah, when I file a case in court, Fatah will enter conditional appearance and file an application or notice to me asking the court to stay proceedings and refer the matter to arbitration. The court will hear my motion, and if it is satisfied that there is an arbitration agreement which covers the case, the court will refer the matter to arbitration. Okay. And that's reference to arbitration here, the court saying we should go to arbitration, will operate as a stay of proceedings. It will operate as stay of proceedings. It won't strike out or invalidate the writ that I issued. And unless the parties agree otherwise, all orders the court had already made in the case will remain. So if the court had made injunctive orders, it will remain even as the parties go to arbitration. So remember, Section 6 is dealing with there already being an arbitration agreement, and one of the parties, instead of going to arbitration, commence the case in court. Then the other party, at the time of entering appearance, objects to the arbitration, the court's proceeding, and asks the court by a motion to send the parties to arbitration. Then if the court is minded, the court will send the parties to arbitration and stay proceedings. This is different from Section 7. Section 7 is where there may not be an arbitration between the parties at all. There may not be any at all between the parties. Or there may have been one between the parties. But when one party commences the arbitration, commences the litigation in court, the other party did not object. So it was just as having waived his right to arbitration. And so the court proceeds to hear the case. But as the court was hearing the case, the court realizes that the entire case or a part of it will be best resolved by arbitration. The court, even though there is no arbitration agreement, or even if there is no arbitration agreement, may seek the consent of the parties in writing and refer the matter to arbitration. And that is why Section 7 is usually used as the basis for court-connected ADR or court-connected arbitration. Under Section 7, there may not be any arbitration agreement between the parties at all. But as the case is ongoing before the court realizes that I think this case will be best disposed of by arbitration. The court, even though there is no arbitration agreement, and with the consent, so here too there is consent, it maintains the idea of party autonomy. May with the consent of the parties order that the parties resolve their disputes by arbitration. So here the agreement to arbitrate was not in existence before the court referred it. So you need to note the difference between the two. Okay. Now, Section 7, subsection 5 says that where in any action before a court, the court realizes that the action is the subject of an agreement, the court shall stay proceedings and refer the parties to arbitration. Now, this is also different. Now, this is where there is a case before a court. The parties had an agreement to arbitrate, but when the disputes arose, they neglected their agreements to resolve their dispute by arbitration, and they came to court. So none of the parties objected to coming to court. But as the case was ongoing before the court realized that you guys even have an arbitration agreement. And the court believes that this matter will best be resolved by arbitration. The court must order the parties to go and resolve their matter by arbitration. So you see the difference between them. Section 6 is dealing with where one party to an arbitration agreement commences litigation. Another party objects at the time of entering of appearance and files a motion. The court hears the motion and then stays proceedings and orders the parties to go and resolve their disputes by arbitration. The Section 7 is when there is no arbitration agreement. But during the course of the trial, the court thinks that this matter is best resolved by arbitration. The court will order the parties, by their consent, if they agree, ask them to go and resolve their disputes by arbitration. Then Section 7, subsection 5 is dealing with a situation where parties had an arbitration agreement, but they still came to court and none of them objected. If the court finds out, the court can order them to go and resolve their disputes by arbitration. So a lot of times you have arbitration questions around this. Please note and then deal with those questions properly, remembering the distinction between the various sections we just discussed. Now let's talk about the arbitral award. After the arbitration, the tribunal or the arbitrator must give an award. Remember, the award is final and binding. The award must be in writing and it must be signed by the arbitrator, stating the date and the place where the award was made. And it must provide reasons for the award, except where the parties agree that the arbitrator should not state the reason of the award. Now, it means that an arbitration award that does not meet this criteria can be set aside. So you need to remember this. The award must be in writing, signed by the arbitrator, indicating the date and place where the award was made, and unless agreed by the parties, must provide the reason for the award. Now, where the award is granted, Section 52 tells us that the award is final and binding as between the parties and their assigns or successors in interest. Then, Section 53 repeats the principle under civil procedure called the slip rule. That's where the arbitrator, after giving the award, realized that he made a typographical mistake. He's allowed to correct it within 28 days after delivering the award, or within any other period as the parties may have agreed. He can also make another award that he omitted in making at the time he made the initial award. So Section 53 essentially allows the arbitrator to correct the mistakes he has made in the award. It is not a form of appeal. It is only for the arbitrator to correct his mistake. Now, where an arbitration award has been given, the arbitral tribunal does not have the power to enforce the award. So you, the victorious party, must take steps to enforce the award. Now, under Section 57, we see the procedure by which you enforce an arbitral award in Ghana. You first will seek leave of the High Court, and when the leave is granted, the High Court will allow you to enter judgment in terms of the award. So you're all doing civil procedure, so you know what entry of judgment is. So you draw up the orders that were made in the award, and then you file it. Filing the entry is what we mean by entering award. And when you enter the award, you will seek leave. If the person fails to pay, you follow the same procedure for execution. Civil procedure, I'm sure you have done that. The rate of FIFE, rate of sequestration, rate of possession, whatever it is, the appropriate means of enforcement, you go by that if the person fails to satisfy the debt. Okay, so the enforcement procedure, immediately you seek the leave of the court and the court grants it, and you enter the award, it becomes as if it is a judgment of that High Court. And so you use the same civil procedure mechanisms to enforce or execute the award. But the award granted can also be challenged. Section 58 gives a long procedure or instances for challenging the arbitral award. But you don't have to chew it. You just have to think about it. And you remember these things. First, remember section 1 on arbitrability. So if the award was about a dispute that is not arbitrable, the judgments can always be set aside. Imagine an arbitral tribunal grants an award on constitutional interpretation. You can always set aside because that is not what's arbitrable. 2, if the tribunal failed to disclose its interest in the matter, so maybe the arbitrator was a judge in his own cause, and you only got to know it after the award, breach of rules of natural justice, you can challenge the award by reason of that. Again, breach of the rules of natural justice. One of the parties was not given notice of the arbitration. He was not informed of the appointment of the arbitrator or of the proceedings, and so was unable to attend. Grounds to set aside the award. Again, the arbitrator failed to give reason for his award. You can set aside the award. Again, the arbitrator applied a different law than the governing law in resolving the dispute. You can set aside the award. Some or one of the parties to the arbitration suffered some incapacity or disability, and so the person could not participate or appreciate the proceedings. You can set aside the award. So these are things you can easily remember. If the court thinks the award was even induced by fraud or corruption, the court can set aside the award. But the catch is, if you want to challenge the arbitral award, you must challenge it within 3 months from the date you received notice of the award, unless some justifiable reason exists for your inability to file it within the 3 months. What can be a justifiable reason? So think of it. Let's say the arbitrator was a judge in his own cause. I didn't know that he owned shares in the company that I had a dispute with. So he gave the judgment. I didn't even know. 3 months have passed. After the 3 months, maybe in the 5th month, I get to know. I can set aside the arbitral award. Here, although it not come in 3 months, I'll tell the court that the information I am basing on to set aside the award, I did not know it at the time. I am only getting to know of that information now. So I will be allowed to set aside the arbitral award. Okay, so that is also a very important area that you need to have in mind when it comes to challenging the arbitral award. One other thing which forms a ground to challenge the arbitral award is where the arbitrator used the wrong law governing the arbitration agreement. So here it's about the arbitration agreement itself. The arbitration agreement can say that where there is a dispute, it will be resolved by arbitration at this particular place. Okay, and the person commenced the arbitration in the wrong forum or did not follow what the arbitration agreement specifically say, you can set aside the award or you can challenge the award that was granted by that tribunal. Okay, so we need to have that in mind. And the last thing I'll talk about under arbitration is drafting the arbitration clause. The arbitration clause is what will mandate the parties to refer their disputes to arbitration. That's what the arbitration clause does. And so in drafting the arbitration clause, you are required to avoid ambiguity on whether or not the parties have a duty to resolve their disputes by arbitration. So I think just this week, a friend of mine sent me a case, an arbitration case decided in the UK court, National Investment Bank Limited versus Inland International Thailand Company Limited and another. And the problem with that case is what we are talking about. Because some of these things you would think lawyers will never make this kind of mistake, but lawyers always make this mistake. The lawyers who drafted the arbitration agreement said that the parties may resolve their disputes by arbitration. And so when a dispute arose, one of the parties, I think the bank, National Investment Bank, went straight to court in Ghana to have the dispute resolved. The case has gone through some long hurdle and it's ended up in the English court because one party commenced arbitration in England and that party did not participate and it led to it. But the English court said that the arbitration clause did not mandate resolving the dispute by arbitration. It only provided an option for you to resolve your duty by the dispute by arbitration. And that is a wrongly drafted arbitration clause. If you want the parties to resolve their dispute by arbitration, you must clearly state that the dispute shall be resolved by arbitration and then provide whether you are given a forum or how the parties will choose the forum, and then also state the governing law of the contract. Okay. So some textbooks have come up with what we call the 7 deadly sins of drafting an arbitration clause. And if you go through your past question, it is a very common question. Either they will ask you to write the 7 deadly sins, or they'll give you a fact pattern, like I mentioned earlier. and the arbitration clause will have an issue in the way it was drafted. When you see a question that has the arbitration clause spelled out in the question, always remember that they are requiring you to discuss one or more of the 7 deadly sins. So what are the 7 deadly sins of drafting an arbitration clause? Equivocation. You cannot equivocate. So you must expressly state without any ambiguity that disputes shall be resolved through arbitration. If you have a clause that uses the word may, someone can say that the parties shall resolve their disputes by either arbitration or mediation. That is equivocation. Okay, so it must be emphatic that the disputes shall be resolved by arbitration. So the first deadly sin is equivocation. The second is inattention. Okay, and this concerns the type of dispute resolution that will best resolve the dispute. So the dispute that the parties have, what is the best way? What is the best mechanism for resolving the dispute? Arbitration may not be the best way. So that is when you hear people say that, oh, no one paid attention to the arbitration clause. The person who drafted it did not pay attention to the transaction which they want the parties to resolve by arbitration. So the transaction is of a nature that cannot be resolved by arbitration. Or arbitration is not the best way to resolve it. So again, think about Section 1 of the ADR Act. Imagine the contract was about the environment. And in the contract, the party said that if there is any failure to do A, B, C, and it leads to some environmental impact, the dispute will be resolved by arbitration. The person who drafted did not pay attention to the contract. Okay, so that's the sin of inattention. You must pay attention to the transaction to determine whether arbitration will be the most suitable dispute resolution mechanism to resolve the dispute. Then there is the sin of omission. There is the sin of omission. The sin of omission is when the person does not state anything at all as to how the dispute will be resolved. So he omits the most important thing, which is how the dispute should be resolved. An example will be any dispute arising out of this agreement will be finally resolved by binding agreement or by binding arbitration. That is all that the person said. How are we going to select the arbitrators? Where is going to be the center of arbitration? Which rules apply? So you must state that all disputes shall be resolved by arbitration based on the Hong Kong Center for Arbitration rules, something like that. So that on how that address should be selected, the venue and all of those stuff, we can look at the appropriate rules mentioned to determine that. So omission is when you omit an important ingredient in the arbitration clause. which means we cannot tell how that particular thing, which is required to be done under the arbitration proceeding, will be achieved by the parties. Okay. Now, the opposite of the sin of omission is the sin of over specificity. This is when the person who drafted the clause provides too much information so that you cannot even make use of the clause. You cannot have a good arbitration by reason of the clause. So here, the person has drafted a clause that it becomes very difficult to use it in practice. It captures almost, like it touches on almost everything that it leaves the arbitration tribunal without any leeway to do anything on its own. So in the example I have, it says something like the arbitration will be conducted in accordance with the federal rules of civil procedure applicable in the United States District Court for Southern District of New York, and the arbitrators shall follow the federal rules of evidence. So something like this. Okay, so it's like saying the dispute will be resolved by the Contracts Act in Ghana, following the civil procedure rules and the evidence rule. The arbitrators cannot apply any other law. Like, it says so much, it leaves no room for the arbitrators. Now, the problem with this is if something comes up that the arbitrators should have used a better means to resolve, they will not be able to do so because they have been their authority to use their discretion to maybe resolve that dispute has been completely ousted in the way that the clause was drafted. Okay, so you have to avoid over specificity. It's the clause must capture the necessary things. That is, the disputes must be resolved by arbitration and tell us the governing law and maybe the rules for selecting the arbitrators. That is it. Don't go into detail telling us the law that the tribunal must apply, like restrict them specifically to certain laws and those laws alone. That will amount to the sin of over specificity. Then there is the sin of unrealistic expectations. There is also the sin of unrealistic expectation. Now, this happens where the clause contains some expectations like the time within which the arbitral tribunal must hear and give its award, and which realistically cannot be achieved. Imagine an arbitral agreement saying that the tribunal must resolve the dispute within 3 weeks. Okay, so those are unrealistic expectations, and the clause shall not contain such provisions. Okay. Then there is litigation envy. And this is a sin committed by lawyers a lot of time. See, most lawyers are litigating attorneys. And so whenever they are drafting contracts, they draft it with litigation in mind. So even when it comes to the arbitration clause, they still draft it in a way anticipating litigation. So they put litigation ideas into the drafting of the clause. And what they will do is that they will say that the arbitration must follow court rules. Okay, whenever it is seen that there arbitration must follow court rules or is imposing certain court standards on arbitration, we say that it is litigation envy. That is one of the sins of drafting an arbitration clause. And the last one is overreaching. Now, overreaching is when the clause is sometimes in favor of one party. Okay, is in favor of one party, neglecting the interest of the other party. The courts are likely to set aside such forms of arbitration clauses, or even when the parties agree, one party's participation will not be forthcoming. So an example would be a clause. One of the parties is Chinese, the other party is English. And the clause says that the arbitration center will be in China. The language of the forum will be only in Chinese. And all documents filed before the court or the tribunal must be filed using the Chinese language. This is overreaching. It is so tilted in favor of one party that it ignores the interests of the other party completely. This would not be accepted by the courts. This will not be accepted by the courts. Okay, so I think our time is up, but if there is any question, you can bring it up and then I'll address it before we bring the class to an end. If there is any question, you can ask at this time. Yeah, please.
Hi,
Just
please
so
go
your mic
ahead.
can add.
All right, Senior, can you please make a distinction between the seat of arbitration and then the venue of arbitration? Can you please clarify it for us?
So when we speak of the seat, we are talking about the center. Okay. And by that, we are usually speaking about the rules. That's the lex fori that we will use for the arbitration. But the venue is the place where the arbitration will take place. So an arbitration can be in a form that its seat is in the UK. Okay. But the parties will not be at that particular place. Okay, they won't be in London. The venue for the arbitration may be in Ghana. So the seat is basically like the place that has legal jurisdiction over the claim, so that the seat is dealing with the rules that will be applied. So there can be an arbitration where the tribunal seat is in the UK. Okay. And so when an award is given, the award is deemed to have been given in the UK, but the tribunal actually sat in Ghana. That's the difference between the seat of arbitration and the venue of arbitration. Please, do you get it? So think of the seat as the jurisdiction. So the court, that is the tribunal, what is its jurisdiction? And here I'm talking about like the geographical jurisdiction. Okay, not the place it is sitting, but the legal geographical jurisdiction. So if it is seated in Ghana, it means it's applying Ghana's lex fori, and the award will be deemed to have been given by or under Ghanaian law. Okay, but the venue is the actual place where the tribunal sat. Please, I hope you get it.
All right, thank you, Senior. Perpetual, Ms.
That's
Perpetual,
fine.
You can also go ahead.
Yeah, hello, Senior. Please, my name is Perpetual. I would like you to throw more light on the exception on the separability. I didn't get that well. Thank you.
So I'm saying that the doctrine of separability is saying that the substantive contract and the arbitration agreement or clause should be treated as two independent agreements, so that the invalidity of the substantive contract will not affect the arbitration agreement. However, I'm saying that that principle is subject to an exception where the substantive agreement never came into existence. So I think an example would be company law. I'm sure you remember you are even in first, so you're still doing some bit of company law. So when you did company law at LLB and maybe in the law school, you learned about the fact that a company is birthed only at its incorporation. And that is the reason why pre-incorporation contracts are usually not binding on the company. So imagine that there is a pre-incorporation contract. There's a contract you purport to have with a company before its birth, and by which you sold some goods to the company. And that contract said that where there is a dispute, it will be resolved by arbitration. But when the goods were delivered to the promoters, they never incorporated the company. So here, can you say that the disputes, you want your money and the money is not being given? Can you say that the dispute should be resolved by arbitration because there is an arbitration clause? No, because the other party was never formed, and therefore the contract never came into existence. After it had been formed, it may have ratified the contract, but this never happened. So the contract never came into existence. So one, you never had the contract with anyone. You get that? So when this is not present, you cannot claim that based on the doctrine of separability, the matter must be resolved by arbitration. That's why the common law courts, and actually all courts, say that separability will only apply where there is actually a contract between the parties. Where there is actually a contract between the parties and one of the parties is challenging the validity of the arbitral, of the substantive agreement. That is a situation where you can say this matter must be resolved by arbitration. But if the agreement never came into existence, separability would not apply. Please, does it clarify your
Yes,
conflict?
very well. Thank you.
You're
Yes,
welcome.
thank you.
You're welcome. Please, any other question? Okay. So, Fatah, I think there isn't any question.
I think someone is trying. Farouk is trying to ask a question. Farouk, please go ahead. So first, we'll allow
Yes,
for
Farouk,
just two more
please go
questions.
ahead.
Session one end.
Thank you. Please just a quick light on competence.
Yes,
I don't
so
know if you can hear me.
yes. So I said that competence is the principle that says that it is the tribunal or the arbitrator that has the power to determine questions of its jurisdiction or challenges to its jurisdiction. So if there is an arbitral tribunal and one of the parties is saying that on this issue, this tribunal does not have jurisdiction, competence is saying that the competent body to determine whether or not the arbitrator has jurisdiction is the arbitrator himself. That is the whole idea of competence. So you cannot take that issue to court. The court said that no, go back to the arbitrator. Let the arbitrator determine whether or not he has jurisdiction. It is only after the arbitrator has decided that it has jurisdiction and it fails or you are still aggrieved, that is when you can challenge that decision by applying to the court to determine whether the arbitrator was right. Okay, but the initial decision on whether or not the arbitrator has jurisdiction must be determined by the arbitrator himself. That is the idea of competence. Farouk, do you get it?
Yes, please. Thank you. Very good.
Yes.
All right, and I think the last one would be what I have in the chat box now that says, could you please repeat the three factors under the arbitration or arbitrability of a dispute?
The three factors under the arbitrability, I think that the question must be rephrased properly because I don't know what the person is referring to.
Nina, if you could just unmute and then ask the question.
Okay, so you mentioned that under the concept of arbitrability, the arbitrability of a dispute depends on three factors. You mentioned
No, I
section
said it
1 of the
depends on
ADR
two
Act.
factors.
2, okay. I had 3,
Yeah.
sorry.
No, it's 2. So one is section 1 and the other one is the contract itself. Okay. So section 1 specifically lists certain matters that are not arbitrable. Okay, they are not arbitrable at all. And then I said that, so for those matters, even there's an arbitration agreement that says that you should submit such an issue to arbitration, the arbitration tribunal does not have jurisdiction. Okay, then the second one is under the contract itself. And I said the contract, that is substantive contract, can state, sorry, the arbitration agreement can state that only certain disputes arising under the substantive agreement are arbitrable. So I used the example of a commercial arrangement for goods, where the arbitration agreement states that disputes concerning payments, delivery are arbitrable. So it means that's left out questions concerning breach of the agreement. So if there's breach, a dispute concerning breach, you can't go to arbitration. If you go to arbitration, the tribunal on competence will say that I don't have jurisdiction. This must go to court because the agreement said that I can only hear disputes concerning payments and then delivery of the goods. So it is the two, the one that's section 1 and the way the arbitration agreement is captured. Nina, do you get it?
Yes, please. Thank you very much.
You're welcome. Okay, so I